But, may I be permitted to mention item number 35? This matter is appearing sometime, Lordship. Some urgency is there, Lordship. The tribunal, that's the Consumer Forum, Lordship, has fixed the date for the passing of the judgment, where, Lordship, there was an application for transfer of the matter on the ground of bias was alleged, and which was, Lordship, National Commission has given the view that this kind of matter where the transfer prayer has been refused by the state tribunal, is the only the constitutional court can take up those matters and interfere. Lordship, this order has been passed. Lordship, today it is appearing as item number 35. Can it be taken up sometime today, Lordship? If it is possible, then I can give the notice to the other side.
Who is your other side? Are you aware?
Lordship, I know the state respondents and the Union of India who are appearing. I can intimate them. And Lordship, I know the lawyers who are appearing for the private respondents also.
Can you come at 2 o'clock?
That will do. Lordship, I will try to give.
Your Ladyship, may I permit to mention a matter, item number 36. The
36.
36. The petitioner are railway hawker at Birati railway station. There is the eviction notice. Eviction notice has been issued under section 147(2) of the Railways Act. Even though notice did not specify what is the provision under which provision are the Public Premises Eviction Act or Railways Act, that the eviction schedule date fixed on 1st December 2000. That is Sunday, Your Lordship. That I have mentioned the matter on Tuesday. Your Lordship directed the matter to appear on Thursday. Matter had appeared in the upgraded motion, but however, due to business of the court, the matter could not taken up. Can it be taken up today, Your Lordship, at 2 p.m.? Because this is the notice, Your Lordship.
Are you aware who is your other side?
Your Lordship, I have to serve the notice. I have to serve the notice to learned ASG because
Not to the ASG. ASG will not accept notice. You have to serve notice in the office of the Ministry of Law and Justice.
Ministry of Law and Justice will not accept the notice in respect of railway. I will serve the notice of Koilagata and the fairly placed.
Koilagata and fairly placed wherever. If you can get hold of the learned counsel, then you can come at 2 o'clock. Otherwise, I cannot help.
Your
Next.
Ladyship, kindly fix the matter at 2 o'clock, Your Lordship.
Bring your other side. It cannot be taken up ex parte. Get hold of your learned advocate for the adversary. Come, then I can see.
Lordship, may I permitted to?
Yes.
Lordship, may I permitted to mention one matter, Lordship? This is a PHE matter that I have mentioned before also. Lordship, the construction of PHE overhead tank,
yes,
without any rules and regulations, just Lordship on the next
what you
next
want?
plot, Lordship.
What
This
you
is
want?
yes, Lordship. This matter is appeared as item number 37. Advocate Oshim Kumar Ganguly and Advocate Bilal Sheikh is appearing in this matter. Lordship, any time as per your Lordship's convenient, Lordship.
Next week we can see. Not today. Nothing.
Kindly,
can be
Lordship, this
today it cannot be done.
Your Lordship,
Yes.
may I permitted to mention one matter? Your Lordship, I intend to file one writ petition of Kuch Bihar district. I am seeking leave of this, Your Lordship, to file and affirm this writ petition.
Why is leave required?
There is some urgency, Your Lordship. My account has been freezed. I am a petrol pump. My entire business is collapsed. I'm not being able. I approached the bank. I approached the RBI. Nobody is listening me. My account is freezed. I have not been provided with the reason why my account has been freezed.
File it in the department and give the number.
I'm grateful, Your Lordship. I'm grateful.
To mention one correction of the order related to the circuit bench Jalpaiguri. Order was passed. The correction non-teaching staff group C instead of group C, it was mentioned group D. Order was passed on 30th September 2024 relating to the circuit bench.
September 24. What were you doing for so long?
In the petition, the correction.
No, but then why such delay in mentioning?
Missed the after communication of the order, my lord, they have.
It will appear for correction. Give.
My lord, may I permit to mention?
বুকে আছে পরিবার somebody over there, the bench is sitting, the circuit is on.
circuit is on, my lord. The order was passed by your lordship. That's
No,
all.
but then I remember this typographical errors correction was made there only. You check up.
Yes.
If it can be done over there, then it is all right. Otherwise, because without the file, correction cannot be done.
It has been sent there, my lord. The file has.
Only for inserting one thing, the requisition has to be sent, the file has to come, all records are of the circuit bench. Check up if it can be done over there by the honorable judge having jurisdiction, then it is all right. Otherwise, let's see.
My lord, may I permit to mention one thing? The petitioner executed work in 2021 assembly election, but till date he has not get any payment. Matter is in the list. My lord, if your lordship take this matter next week, any days.
Yes, next week, any date, we will see.
I have given all
Please
notice
keep
to
it
the
with you.
other side. my
Lordship,
lord.
may we
Yes.
permitted to mention, Lordship, my interim order is due to expire tomorrow, my lord. Lordship, kindly include the matter in the list, my lord.
Tomorrow is a non-working day. The interim order will expire and you are mentioning today.
No, Lordship, I mentioned yesterday, Lordship, I
Same
mentioned a
matter
bit
I
later, my lord. That's why Lordship didn't agree to it. But I mentioned yesterday, my lord.
এই মামলাটা কালকে মেনশন হয়েছিল?
Yes, my lord. I had come, I had talked to them.
My lord, in the same matter, I seek to mention, my lord, I am suffering interim order in this from September 23, my
No,
lord. I am requesting for a inclusion in the list, my lord. My vacating application is pending, my lord.
Yes.
My lord, in the same matter, I am seeking for an leave to mention for inclusion in the list, my lord. I am
Same matter.
Yes, my lord. WPA 1719119, where I'm suffering the same interim order suffering to September 23, my lord.
জানা বাবু এখানে কোর্ট চলছে।
Interim order in the matter, my lord, it can be included in the list, my lord. And my vacating application is pending, my lord.
Vacating application is pending. Vacating application will be taken up in its usual course.
My lord, it is not in the list, my lord. It has to be included in the list.
Park. It's not a matter of reminding. If you have mentioned, your slip must be here. If it is not here, it means you have not mentioned. All the matters which were mentioned has been enlisted. Nothing doing. 2 p.m. That 2 p.m. is not the time to mention. Anyway, nothing can be done. It will appear.
May I give the mentioning slip, my lord?
Yes.
My lord, I am suffering interim order since September.
You have filed an application for vacating.
Yes, my lord.
It will appear in the list. Don't give the number. It will appear.
May I be permitted to mention one matter, your lordship, or contempt application, your lordship?
For what are you mentioning?
Your lordship, the impugned order passed by your lordship only.
Why are you mentioning? What is the reason for mentioning?
Because the respondent authorities are not acting, your lordship.
Come later on. Yes.
My lord, mentioning for modification of the order, এই কোর্ট থেকে একটা অর্ডার পাস হয়েছিল 29/7/2024 সেই অর্ডার পাস হয়ে ওটা বলা ছিল যে রেকর্ড কারেকশন হয়ে গেলে আমি স্কুল রেকগনিশনের বিষয়ে আমি ক্লিয়ার হয়ে যাব। তো তার আগেই আপনার অর্ডার পাস হওয়ার আগেই এসডিএলআর থেকে আমি অর্ডারটা আমি সবে রিসেন্টলি পেয়েছি, 1 সপ্তাহ আগে পেয়েছি ফর ফিট ফর কারেকশন দ্য আর রেকর্ড। তো এটা মডিফিকেশনের প্রয়োজন আছে এই অর্ডারটা, নাহলে আমি মানে সেই সময় কোনো রিলিফ পাইনি আমি। আদার সাইডকে আমি মেনশন করি যদি একটা
আপনার
নেক্সট উইক
মামলাটা কি এখনো পেন্ডিং আছে
না
না
মামলাটা ডিসপোজ অফ হয়েছে।
ডিসপোজ অফ
হ্যাঁ
মামলা আপনি মেনশন করে মডিফিকেশন করা যায়?
হ্যাঁ, যদি আপনি পারমিট করেন আমি আদার সাইডকে নোটিশ করে দিচ্ছি দিয়ে।
এটা কি এইরকম ভাবে হয়? আপনি কি উকিল বাবুর সাথে কথা বলেছেন? আপনার মামলা কে করেছিল?
যে আমি নিজেই ইন পার্সন করেছিলাম।
ইন পার্সন করেছিলেন।
তো
আপনি কি আইনটা জানেন? মডিফিকেশন এইভাবে হয়?
মডিফিকেশন অর্ডারটাকে মডিফিকেশন চাইছি।
হ্যাঁ, অর্ডার মডিফিকেশন হাওয়ায় হয় না, তার জন্য একটা দরখাস্ত করতে হয়। দরখাস্তটা কোথায়? ইয়েস।
May I permit to mention, my lord, this extension for interim order, my lord, and that is
When is it
expired,
expiring?
my lord, tomorrow, my lord.
Tomorrow? Go off to sleep. Call the list, please.
Your lordship, my apology, your lordship. Without the leave of your lordship, they are not allowing me to file and affirm the writ, your lordship. The matter I mentioned, your lordship, the Kujbia matter, without the leave of your lordship, department will not allow me to affirm or file the writ petition.
Kujbihar matter will go before the circuit bench, isn't it?
But if leave be granted, I can file this in the department in here.
Why will the court give you leave?
Your lordship, there is an extreme emergency, your
Extreme
lordship.
emergency, the bench is sitting over
My
there.
account is freezed.
The bench is sitting over there. You go before the bench having determination.
Your Lordship,
Get
may I
to
be
it.
permitted to mention on electricity matter? It is an electricity matter, but appearing in the
Yes,
other than
item
electricity.
number 1 in the original side.
The item number 1 for the alleged contempt of Mr. Gurudas Mitra is leading me. Due to his personal difficulty, he could not come today, my lord. I'm praying for a day's accommodation.
The same prayer had been made on my behalf, my lord, when the matter I seek to recall was passed.
What happened? Your prayer was made and the court disallowed the prayer?
Court allowed an extension very legitimately, but the respondent contender suppressed that he had already disposed of the matter. And that order my clients received on the day my lord took up the matter. Kindly seize, my lord. My lord's order was very fair. An extension was sought for and granted. I do not have any quarrel with that. But this, the subsequent annexure P3, page 13, page 13 of this application. My lord will turn to page 14. But the alleged, this is GA number.
Are you referring to the contempt application?
I'm referring to GA1.
GA, yes. Page 13.
Page 13 is the order that he has already passed. Before my lord had passed.
But then today an accommodation has been sought. I'll not
Then
open
my
the
lord
file.
will not
Only
take
not
up the
today.
order on Monday, my lord. I won't be
Yes,
there.
yes.
But on Tuesday, my lord.
All right, Tuesday.
Tuesday.
I'm deeply obliged, your lordship.
My lord, I am appealing for the petitioner, my lord. Settlement, process of settlement is already going between the parties. So, my lord,
Parties
my
means?
instruction
Parties means?
Private respondent and the petitioner.
Well, the
Private
if I may indicate, my lord, and for the respondent number 2 and 3, your lordship will have to probably, my lord, this matter will go before the intellectual property division. Look, this is your lordship's similar order, your lordship
All
has
right.
passed. This concerns trademark.
Very well. Same order.
Grateful to your lordships.
না না ডিসপোজ না, এটা ইন্টেলেকচুয়াল প্রপার্টিতে চলে যাবে।
I'm extremely sorry to my lord.
Item number 3. Nobody is there? 2022. Dismiss for default.
I'm extremely sorry to interrupt, my lord. Client will face irreparable loss, my lord.
কি হচ্ছে? আরে এটা কারেকশন, কি কারেকশন? ঠিক আছে, দিয়ে দিন, করে দেবে। এটা কেন এসছে টু বি মেনশনড? কোথায় কারেকশন? অ্যাসিস্ট্যান্ট রেজিস্ট্রার হয়ে গেছে, এটা অ্যাসিস্ট্যান্ট ইঞ্জিনিয়ার হবে।
Mr. Naik was appearing for the WBCL in the item 2.
Your Lordship, I appear for the respondent number 2 in item number 3.
Why to be mentioned?
No idea.
জানা বাবু, to be mentioned কেন এসছে?
Your Lordship, this matter was mentioned by the petitioner. Your Lordship, it's a surrogacy matter where we are to take possession. There's a section 14 order. But he has also checked section 17 in the DRT.
No, my lord, it is not allowed. As my lord, the possession notice
Your application before DRT was
is
not allowed.
taken by the DRT as the format of the said.
For any reason whatsoever, then you can prefer an appeal. Why before the writ court?
My lord, the possession notice is not as per the format given in the Securitization Act. Their possession notice.
There is a particular forum to deal with this
No,
issue.
my lord, the possession notice, my lord, kindly have a look in page number 22 of the writ application, my lord. It is the possession notice. It is only a vacating notice is given, and the possession notice format is this as per Rule 8(1), my lord.
Why will the court look into all these things?
My lord, and the said order passed by the learned CGM is beyond 30 days, my lord.
You take steps in the revision or whatever. Why 226 jurisdiction has
They
been
have
invoked?
already served us the notice, and Monday they are going to take the possession.
And the writ court will interfere
My lord,
without having any jurisdiction.
my lord, kindly say, my lord, as per section 14 of the Surfacy Act, the said application before the learned CGM was made on 28 March to 2024, my lord, and the order was passed in the month of October. But as per the
Why? I just cannot understand. Either you are not trying to
my lord,
understand.
we cannot approach before the DRT because there was no compliance of possession, symbolic possession of the said property.
বইটা দিন তো দেখি।
Your Lordship,
My lord, kindly see Rule 8(1) and page number 22, my lord. The possession notice. This is the prescribed format of the possession notice, my lord. But the said possession notice as served is not as per this said format. So the possession has not been taken, my lord. And we are not unable to approach under section 17.
You are the bank.
yes, sir.
Tell me one thing. Did you all initiate any proceeding?
We have initiated the proceeding under Surrogacy Act.
Yes.
Notice under section 13(2) has been served.
Right.
Your Lordship, we then directly approach the court below because as per the judgment of Standard Chartered Bank versus Noble Kumar, we can directly approach the court below instead of serving us possession.
My lord, after that, my lord, the said learned.
So from 13, you directly go for taking possession.
I go to file a section 14 application.
Yes.
An order has been passed under that application and it has been recorded in that order. The judgment has been recorded in that order wherein I can directly approach the court.
My lord, kindly see page number 25 of the application, my lord.
Here the learned CGM ordered, appointed commissioner shall give the possession notice to the authorized officer of the secured creditor and the borrower to be served.
How much is due and payable?
14 lakhs, my lord, in the possession notice and 12 lakh in the demand notice under section
13 to demand notice.
12 lakh.
12 lakhs 50,000 is due and payable.
And in the possession
That is
notice,
the principal amount due and total amount due is 13 lakhs 51,762.
With
and in
interest.
the possession notice.
The petitioner is the borrower.
Yes, my lord.
Are you willing to pay?
Yes, my lord.
Yes.
Yes.
Why did you not pay after receiving
My
the
lord,
13 to
they have-
notice?
They have not intimate or given reply to the representation made.
Reply, where is the money?
My lord, we are eager to settle the said matter, but they are now telling that we will not settle it.
Can this matter be settled?
I don't have instructions regarding any settlement.
Because the
procedure.
petitioner undertakes to repay the loan amount.
Then let me come back with instructions, Your Lordship, regarding
my
the
lord.
settlement.
Are you all going to take possession immediately?
We have just, the court bailiff has just posted the vacating notice.
Any date has been fixed?
No,
Yes, my
sir.
lord.
We will not
19 yes.
Where is the date?
My lord, 19th November in page number 22, my lord.
On or before, you have been requested to vacate before 19th of November 2024. That date is long over,
Yes,
right?
And,
And
they have
shift.
already challenged this
No,
notice
it
before
is-
the learned.
No, it is not allowed.
Yes, ma'am.
It is not allowed.
Yes, madam. Kind.
1 minute, 1 minute.
Notice.
And
This is the notice.
on or after 20th. So they have not yet taken steps for vacating you or throwing you out.
Yes, my lord.
My lord, they
Your
have
learned friend
Yes,
is agreeable to pay off the
Settle.
entire dues. And you are concerned with the money.
my lord.
What is the amount?
My lord, amount is 12 lakh.
Let the bank say
13 to notice. Sir.
13 to notice is 12 lakh or something. It has been mentioned just
There
now.
is certain interest as on date.
Certainly, certainly.
My lord, in terms of 13 to, my lord, there is a due of 13 lakhs 51,762.
Thereafter, what is the date of 13 to?
August 2023.
So 1 year has passed by.
Yes,
So
1 year has passed.
something more will be
Certainly, my lord,
payable
term-
to
yes,
you.
my lord.
Give me the figure. The petitioner is eager to pay it off.
But then kindly pass it over, man. I am taking instruction.
Please. 1 o'clock?
Yes, my lord.
Come at 1 o'clock.
My lord, this is the affidavit of.
And ma'am, moreover, they have already challenged this service
No, my
section
lord.
before the
It
learned
has
here.
not been allowed, my lord. In
That should
absence.
that should have been disclosed by my learned friend.
Yes, we have already disclosed it.
4.
Lordship, item number 4, I am on behalf of the petitioner, Lordship. Lordship, with your Lordship, I am filing affidavit of service. Lordship, the brief fact of this instant matter is that one urban acquired gift deed was issued in favor of the petitioner. And Lordship, according to the rules of this deed, within 10 years, the property cannot be sold out, save and except in case of extreme urgency. Now, Lordship, the petitioner is suffering from cancer. I have annexed the medical document. And Lordship, due to petitioner's treatment, the huge amount is highly required. And due to financial.
Did you approach the authority with your friend?
Yes, I have approached the
Did they
authority.
consider?
No, Lordship.
Not yet considered.
No, Lordship. My representation has not been considered.
Page.
It is pending, Lordship.
Page.
Lordship, I humbly draw your Lordship's kind attention on page number 30.
30. Show me the deed once.
Lordship?
The deed.
Deed. Lordship, page number 26, Lordship.
20th of January 23. So it's just
1 year.
2 months less than 2 years.
Yes. So, Lordship, as per the norms of this deed, Lordship, within 10 years, I cannot sell out, save and accept the permission.
Where is that provision?
Provision. Next page, page number 27, Lordship.
Yes. Which portion? 27?
Shall have no right. Your Lordship got it?
No.
Line number 1, 2,
11,
3,
11.
4, 5, 6, 7,
Top 11.
Yes, donee shall have no right 7 to alienate or transfer within a period of 10 years from the date without obtaining prior permission of the donor, which shall be obligatory. Please come.
Well, he sent the letter by post, which is under consideration of the department after inquiry by the consultant assistant.
Lordship, but till now it is pending, Lordship.
Petitioner.
আমাকে বলতে দিন, আমি তো বলবো।
No, it's over. Do not go on. For the purpose of your relief, it is over. No further submission.
Lordship.
The petitioner was allotted a piece and parcel of land by the State of West Bengal as urban-acquired gift. By treating the petitioner as a refugee on 20th of January 2023. Stop. The document, the subject indenture specifies that the donee shall have no right save hereinafter provided to alienate or transfer in any way the land comprised in the schedule within a period of 10 years from the date of the document without obtaining prior written permission of the donor. Stop. Paragraph. The petitioner submits that he is currently suffering from cancer and he requires immediate financial assistance for his treatment. Stop. An application, paragraph D, has been filed before the respondent authority seeking leave to sell out the property mentioned in the schedule of the deed. In August 2024, stop. The same is alleged to be kept pending. Paragraph. As it appears that there is a provision for alienation of the subject property only upon a permission being granted by the state, and the permission sought for by the petitioner is pending. Accordingly, the instant writ petition is disposed of by directing
Number 5.
SDO. You've taken instruction. Very well. And did the SDO say that he will be the authority to?
He is in the charge.
He is in charge.
He has not made participation of the other respondent. That is the subdivisional relief rehabilitation officer L and L department. Left hand side of the bottom. But it is jointly signed by the subdivisional officer Barak. And the report has been by
Subdivisional officer, consideration of the representation made by the petitioner in accordance with the prevailing rules. At the earliest, but positively within a period of 4 weeks from the date of communication of this order.
My lord, sometimes, my lord, there will be spot.
An opportunity of hearing may be granted to the petitioner for ascertaining the actual reason for sale of the subject property. Stop. The prayer of the now a reasoned order shall be passed and communicated to the petitioner immediately thereafter. Stop. Learned advocate for the petitioner is directed to forward the copy of the representation along with all documents in support of his prayer to the aforesaid respondent at the time of communicating the order of the court disposed. It are recorded.
Deeply obliged, Lordship.
But instead of 4 weeks,
Applicant is service.
formalities is there, madam, 8 weeks. Otherwise, madam, they will come before the order of contempt.
Cancer patient.
I know that. madam.
This is the
I'm in
reason.
financial strains.
Make it 6 weeks in that case.
Lordship, I am suffering from financial hardship, Lordship.
At the earliest, outer limit 6 weeks.
Lordship.
My lord, in item number 5, my lord, I tender my apology, my lord. My lord, the similar issue is pending before the Honorable Supreme Court, my lord. I have taken written instruction and I would like to withdraw the matter. I'm tendering my apology, my lord. I
took leave yesterday, my lord.
It was mentioned yesterday.
Yes. I took leave, my lord. They were not aware of the order, my lord. I took it out from the server to yesterday, my lord, and this issue is pending. So it's my duty, my
Please
lord.
come, learned advocate appearing for the petitioners. Petitioners.
The instruction on
Submit that. The issue in question is pending consideration before the Honorable Supreme Court, and the petitioners are not inclined to proceed with the writ petition any further. Stop.
It ordered the
petitioner has made a written communication to the learned advocate intimating the above. Acha. Before the Supreme Court in civil appeal diary number. Withdrawn. He not pressed our applicable.
But I tender my apology, my lord.
I appear on behalf of respondent number 6, my lord.
But I'm appearing for the state respondent.
No.
No, Lord, it is very surprising, my lord. Picture, one of the room in which the meter to be installed. My lord, according to my learned friend, it's cost 30,000 or more than that. My lordship, it appears, my lord, this is, my lord, I am giving the picture just, my client has taken these photographs. It appearing, my lord, at least the same was built up at least more than 20 years ago. And this is the meter room.
30,000 rupees.
Very surprising, my lord.
30,000
This is
rupees.
only.
No, that's newly constructed meter room.
Which
There is a
newly
newly
constructed?
because
meter room?
Because Milord, kindly Milord sees this. The previous writ petition was filed in 2023. Thereafter, again 2024. This writ petition again 2024.
But this picture is of
Does
only
it,
Milord,
one minute, does it mean it? Look at the picture, show it to him.
Milord, I am giving this.
30,000 rupees.
This is number is there, Milord.
Milord,
2118.
Milord, what instruction I have received, Milord?
No, you should filter whatever comes to you.
Yes, Milord,
and place proper facts before the court. Your client will say it costs 1 lakh of rupees and you make submission.
No, Milord, that's not.
Then, at least to the court, you should be proper.
All the Respondent number 4 and 5 and has already paid my lord 20,000.
How much?
20,000.
When respondent number 4 has paid?
4 and 5. All of them has contributed to the construction of this.
Yes.
All of them individually had paid 10,000 rupees.
10,000. That means 30,000?
Yes. Madam.
Is this a result of 30,000 you say? Please come.
Right, at least some payment may be given.
What does some payment? Are you begging?
No, my lord, I am not begging, my lord.
Then?
That's a common meter board position. They are.
No, I have instruction that inside matlab, the plasters. Some plasters has been taken place. After that, that the construction has not been changed. This is the construction where they are intent to the
The photograph of the meter room where the meter will be installed has been placed before this court by the learned advocate representing the petitioner. Stop.
May I take leave, my lord?
Yes, yes. The CESC Limited shall take steps to place the meter of the petitioner in the meter board inside the said meter room. Stop. Next. The petitioner shall pay the shall pay an ad hoc amount. No, the petitioner shall and the amount that is to be paid by the petitioner for the for contribution of his share for constructing the meter room shall be settled amicably in between the parties. Stop. And the meter shall be installed positively within a period of 3 weeks. Stop. The matter stands adjourned till 20th of January 2025 for recording compliance.
Lord, I have already submitted my affidavit of undertaking.
It will be open for the CESC Limited to take the assistance of the police in the event there is
But
any.
that is already given. That is already given. That is already
আচ্ছা ঠিক
given.
আছে তাহলে ওটা বাদ দিন ওটা কেটে দিন ওটা কেটে
Or
The
deduction
private
of the police
respondents are
cost.
restrained from creating any obstruction to the men and agents of CESC Limited at the time of installation of the meter.
Lord, I have already submitted my affidavit of undertaking. I had
Yes.
submitted that I have no objection if they
Next.
take electricity connection.
Hello.
Direction for filing affidavit in respect of item number 1830. May I file?
We have not been served any copy.
Lord, we have not been served with the writ petition. No, there was a direction in September. We have not been served with it. We are added respondent. They are not serving us the writ petition. No, I'm not about you. The writ petition, Lord. Kindly direct.
Why has writ petition not been served? Allegation is that writ petition has not been served.
No. They have not been added as a party.
My Lord, there is
Not been added.
No, Lord, there is an order, Lord. I shall show you the order, Lord.
No.
Yes. Please show.
Lord, first order, Lord. Okay. On 7 in it together. Added respondents. We are the added respondents. We are denying this order. They won't serve us.
এটা দেখানো উচিত না কিছু বলে তাও দেখা ওটা এটা দেখি দাও
See, show it to him. Show it to him. Who has received service?
25/8/23
My Lord, I have served long back.
Saika Khan.
On my
Saika Khan.
To the petitioner.
2023.
Affidavit has been served.
Yes.
Which matter? There are two matters.
Brief fail করেছি
In one they have served us, in one they have not.
ওর allegation হচ্ছে 1803 it has been served.
8. And Lordship, this is voluminous plot. Lordship will kindly, I will take out an application plot, subject to your Lordship.
18030.
How you can take an application after 3 years?
18030 has copy been served?
Yes. Yes, it has been. It has been. Saika Khan. Please
The other
see.
matter.
Please see my.
18030.
Allegation is one, my lord. After 3 years, he is filing an application for restoration. That's their.
WP 5368.
They are dragging the procedure.
WP 5368, there is no direction for service.
But it was tagged together. Both these matters have been tagged together.
But then did you get the copy of one writ petition
Yes.
that you have got?
একটু আগে বলেছিল কিন্তু।
Has not been added in.
Sometime back, he is telling that he has not been. Now he is telling he has.
Is not a party to.
What he is telling?
Different prayers in two different writ petitions. In
No,
one I have
no.
So
It's
there's
one
there are
issue.
similar prayers for two petitions.
It's
Your
one
lawyer
issue.
friend cannot say that.
It's one issue
One
for
issue with
pausing
two
of the
prayers.
proceeding.
Ahmad is not a party.
The lawsuit
And then the
directed
trial is going
on 24th of. No.
Going on.
I say no. I have stated everything.
Is deposing my lord.
Adopting the same tactics before the trial.
Same
court.
tactics before the trial.
No tactics.
1 minute, please, not at the same time.
Then we shall argue and we shall go on.
Yes.
Why are they adopting the same tactics? They are saying here, the trial is going on. Before the trial court, they are saying the High Court, it is pending before the High Court. No. But I have stated everything.
Report if the trial is going on or not.
In can number 3. Can number 4. Have a look at my last order dated 24th of July. No, my lord. Have a look at.
I am the de facto upon their summons. I am
Have a look
deposing
at
my
my last order dated 24th of July. Oh, ও কার হয়ে অ্যাপিয়ার করছে জিজ্ঞেস করা হবে। বডি ফ্যাক্ট তো কার হয়ে অ্যাপিয়ার। For whom he is appearing.
Who are you appearing for?
For whom he is appearing.
He's the original complainant. I am the
Up.
complainant of
He has
What
not
is
been
the
added
name?
as a party.
What is the name?
Shafiq Ahmad.
All right. Is there only one de facto complainant or
Not
there are many?
They are
Not
two.
added as a
Two
party.
matters too. They have not made us parties.
Us
Why?
means why?
Why?
Us means who?
Lord, there are two de facto complaints. One is Shafiq Ahmad, the other is Mamta Agarwal.
There is one.
In 18030, who is the de facto?
Shafiq Ahmad.
Hobik Ahmed.
So you've got the brief.
Yes.
But they have not added us as parties as yet. Can you see that?
Why?
Anyway, formal adding, if it has not been done, you are aware of the facts, you have a copy of the writ petition, and
Take out an opposition, my lord. Allow me that time.
why did you not do it for so long?
Lord, because it fell from your lordship, my lord, that the original matter was dismissed for default. That has been restored. Your application cannot be restored. Automatically, you have to take out an application.
But there
I have made the application ready, my lord. My client is suffering from jaundice, my lord. He has not come to court today.
Our application was
I
restored.
shall file it.
Their application was not restored.
See, somebody is pressing for getting the matter heard, and the respondents,
pressing
for
No,
any
they-
reason,
they
I
all
do
the
not
matters
know,
stayed. বলতে দাও।
trying to delay it.
No,
This I can
No, my
understand.
lord, we are not trying to delay it. Why? We are trying
Yes,
to
sir, that is
expedite the matter because the de facto is deposing as PW1 in the sessions court. This they have suppressed from your lordship.
But there are
The
4
trial is
matters.
ongoing. During an ongoing trial, they have an alternate applications remedy in the criminal courts.
Oh.
They are not going for quashing
My,
them.
my
They are
learned friend is
for
going
quashing
into the
case.
merits of the case
On
now.
an
My,
ongoing trial.
my learned friend
Lord,
is not
lordship
going
will
into the
allow me
merits
to
of
take
the
out an
case.
application, my lord. But this cannot be done, my lord.
All these matters are.
They will surpass the. Why have they not gone
No,
there?
all these
Lord,
matters.
Lord, the reason that they have not gone.
Why they have not gone, the council will say why they have not gone there and why they are here.
Well, let us go into the merits of this case.
Lord, lordship will
I'm
allow me
ready,
to
I'm
file an
ready.
application.
No, no.
Sir, if
Our
you
application
know,
was
they
restored,
are
their
going to the
application was
merits
not
and hear
restored.
out the matter.
In my opposition.
Why? He has not been added as a party.
Then
He
why
is
have
not
you
a
served-
defect of complaint. You are
Why-
nowhere hearing. You have no local standing.
Then why have you served me then?
Why?
Upon the order of the court.
The matter where you have been added and copy served, did you file your opposition?
No,
Why not?
because the matter was dismissed, I had filed a
একটা
client
মাস্টার
to that
কার্ড
effect.
an opposition.
Then
It's
from
not
your
a party.
lordship that you have to file another client because the
Opposition.
client cannot be automatically restored.
Obviously, the cannot be automatically
Lord,
restored.
that I have made ready.
Mala, let us go into the merits of this
Ready.
case. It
Allow
will
me
be
1 week's
finished.
time to file
Why
it.
they are trying to drag the
I
matter?
made that ready.
But four criminal matters.
They want an order from this court so that the trial is.
Matlab, all that they want is.
18030 te Mamta
All
Agarwal.
that done the Supreme Court. But let us hear about the matter. Matlab, no, Matlab, look at Matlab's order dated 24th of July. What is the status report? And the next order is 14th of November. Now look at two orders. What is the status report?
18030 te Mamta Agarwal has given a when she is neither a party.
There was a direction for filing a report. Where is that report?
Report is not with me.
Then.
Every day.
So far as the second day it is concerned, my lord, there is a direction for filing affidavit in opposition, my lord. On my lord, the direction was given on 4th of September 2023. My lord, I have given, it is made ready and I have served copy upon them on 25th of September.
Where is the compliance of the direction passed on 14th of November? Where is the report?
That day also they paid for time.
Why not?
They played for time.
My lord, you lot will keep it on any day, my lord.
আমাকে stay দিয়ে তুমি ওটা শুনবে।
Do you think the time of the court is available in such a manner? Any day you keep it? Time was granted to you.
Matlab, let all the proceedings be stayed. Then matlab, they would be aware of it. Otherwise, they are dragging the matter. We are suffering for more than 11 years. It had gone to Supreme Court. Supreme Court had caused these proceedings.
We'll look at the prayers later on. Where is the report?
You would be muttering, you would be shattering, everything.
You lot kindly keep it on Monday, my lord. I shall come back.
See, just see your stand.
I have stated everything in my affidavit in opposition. This is interconnect. It is cropped up from the same incident, my lord. That's why I have.
Then matlab, kindly grant stay in all the matters. Then they would matlab, they would rise up. No, matlab, you have no local standing. No, my lord. Let us start.
In an ongoing session.
Let us start. My lord will decide.
This magnitude.
My lord will decide whether it will go on.
That is what they want. They want a stay.
But we have prayed for quashing of the proceedings.
We want a
Supreme Court
quashing.
and have come back.
We want quashing. Whether my lord will interfere or
There's
not.
a
that is my
quashing
lord.
court sitting in
No,
482.
that is-
My lord.
Yes.
My
We have
lord
got
discussion.
We have got alternative discussion, and this is my last discussion. This is my last discussion.
There is no motion court there.
But I shall show you judgments.
Second need petition, they have gone up for
One after
additional
another, they're
application that has been dismissed, madam. You lot kindly have-
But let them give a status report, then you will say.
After a stay,
When will you bring the status report?
My lord, 1 week time be given, madam.
stay দিন
1 week?
এক সপ্তাহ stay দিতে বলো
Any
আমাদের।
day, my lord,
Then very well, stay for 1 week.
Lord, this is what will happen.
Very good.
No, no.
Because the next date of the trial is on Monday. They don't want the trial to proceed. And I am deposing as the de facto.
But grant us stay for some time, then they will rise up.
No,
and
Lord,
then
in 1 week's time, I have. Keep it on Monday once. I shall come back with the report. And everything it is, I have stated in my affidavit in now.
আসুন তো এফিডেভিট
Mother, I will start on Monday.
Affidavit in opposition filed on behalf of the state in WPA 18030 of 2023 is taken on record.
Mother, this is assignment or can you grant us stay, mother?
ঠিক আছে? There was a direction passed by the court on 14th November 2024.
Mother, grant us
Directing the
stay.
respondents, directing the state to file a report and to serve the same to all the learned advocates representing the respective parties prior to the next date of hearing. Stop. The report has not been filed. Stop. On the prayer of the learned advocate representing the state, time to file the report is extended till Tuesday. Copy of the same shall positively be circulated by Monday. List next Friday. এগুলো ফেরত দিয়ে দিন তো।
Next Friday. তুই থাকবে ফ্রাইডে, নেক্সট ফ্রাইডে? নেক্সট ফ্রাইডে কত তারিখ হচ্ছে দেখো?
ফ্রাইডে হচ্ছে
তুমি আছো? তুমি আসো তো? Or may I need prefer short stay because when they will play like us. We are suffering for more than 11 years. All those matters had gone to Supreme Court. Supreme Court had caused all those proceedings. Then we remanded it back on the prayer of the state. And since more than 11 years we are suffering. Can we grant a short stay, my lord?
Short stay
so long, my lord.
without application of mind is difficult. Mechanical stay, I will not grant.
This is up to your lordship. I will not bargain.
I understand.
I
but
will
then
not bargain with your lordship, my lord.
Had
I
I
am the last
known the
man. I am the last
facts,
man.
had I known the facts, it would have been easy to grant a stay. But then I do not know what the facts
Then
is.
on the next day,
So,
my lord, we shall
yes.
start hearing, my lord.
Yes,
Kindly.
yes.
Grateful to your lordship.
Item number 9.
My lord, the item number 9, my lord, I appear on behalf of the respondent, but I'm sorry, my throat is.
Lord, I appear on behalf of the petitioners, my lord.
My learned friend, read petitioner, but they had obtained a stay of this order. So I have filed an application for vacating of that interim order. Although, my lord, I confess that I have not used any affidavit in opposition, my lord, to the main read petition. My lord, may I tell you, lordship, in nutshell, the fact.
He is the petitioner.
He is
I am
the
the
read
Writ petitioner.
Yes. My lord, they
Today,
have taken out.
will the application be taken up or the writ petition?
I have filed my application for vacating of.
Vacating. What is the interim order? What is the matter about?
Yes, my lord, the subject matter of dispute, my lord, pertains to my client, my lord, the writ petitioner. He is the promoter.
All right.
Subject matter of dispute pertains to some alleged deficiencies apropos a construction raised by the writ petitioner. Now, my lord, there were several rounds of litigation, my lord. Now, my lord, the subject matter of challenge, my lord, are two orders passed by the, my lord, principal secretary under the housing department, my lord.
Who is representing the state?
I'm led by Mr. Amol Kumar Sharma.
Now, my lord, our principal contention before your lordship is that the entire exercise has been undertaken by the principal secretary in terms of the 1993 Promoters Act, my lord. My lord, it could not have been done. It was an act without jurisdiction in view of, my lord, the 2021 judgment of the Honorable Supreme Court, whereby, my lord, the 2016 West Bengal Housing Industrial Regulation Act has been struck down and was found to be unconstitutional. So, my lord,
But I
they were
only
put on
wanted
notice,
to
my
make
lord.
submission on that. How the judgment can stand in the way for the reason, my lord, for which this in a stay has been granted. It is absolutely, Supreme Court has made it clear.
They were put on notice.
1 minute.
They did not
Right now, the matter is more or less ready for hearing.
Yes.
If your application can be treated as an opposition,
My lord,
provided you agree to it,
I will.
or if you intend to file a separate affidavit in opposition, it's up to you.
Lord, may I just take it? Lord, I know, my lord, if I seek time to file affidavit, my lord, again the matter would be delayed. It's a 16 years the purchaser of.
As it is, I am not hearing it today at this position in the list.
My lord,
Now it is up to you.
My lord, give me 7 days time.
Very
My
well.
lord, kindly keep this matter after 7 days with some priority.
Yes.
Only that relief I am
So
seeking.
far as the vacating application is concerned, my lord, perhaps this is barred by second proviso to orders 39 rule 4, my lord.
All right.
This point, lordship may kindly.
If the final hearing takes place, then the vacating application
I do
also.
not have any.
বিরাট কিছু হয়নি তোমার জন্য wait করছে না।
Final hearing হবে।
তো আপনারা affidavit দিয়েছেন?
An application for vacating the interim order dated 16th May 2024 has been filed by the private respondents in the writ petition. Stop. Next. The learned senior counsel representing the private respondents submits that his clients intend to file an affidavit in opposition to deal with the averments made by the petitioner in the writ petition. Stop. Next. Let, if it is opposition, be prepared and circulated by 10th of December. Reply, if any, by 20th of December. List the matter for hearing in the combined monthly list of January 2025.
My lord, may I seek only one indulgence? I know, my lord, this is the usual order lordship passes. But in this case, considering the platinumers, my lord, suffering for more than 16 years, may I seek some preference?
What is the sufferance?
Sufferance is, my lord, he agreed to buy a flat at a specification as per the agreement. When the flat was given possession, it was found it is a total deviation from the agreement.
Now, what is the remedy that you are seeking?
The remedy is the compensation.
Compensation.
Remedy is the compensation.
in
But they have become very senior citizen. That is why some preference I am seeking.
Let it appear in the list. Finish off your pleadings. Then it can be.
Liberty to mention, my lord, kindly.
Liberty to mention.
I think so far the state is concerned.
Liberty
Now,
to
I do not want, there is no need to file affidavit because I think, my lord, entire thing, my lord, depends on first the maintainability, after that the Supreme Court judgment. Now, my lord, that one paragraph, last but one, I think, where the, my lord, the exception carved out, that where's, my lord, that three expressions, my lord, the Supreme Court said, that where sanction, regulation, registration has been done, those are exempted. That means under the old act, either 1993 act or, my lord, the 2017 act. Now, whether this, my lord, the exercise done initially under 93 act and after the repeal of 93, the subsequent, my lord, the West Bengal act, whether that is, my lord, survived because of that exception carve out.
Yes. Next day we'll hear.
My.
Yes.
Okay. My lord, I appeal for the respondent bank. Okay, back for the state.
And I have this matter relates to, my lord,
I can see the earlier order that talks of settlement you
Yes,
submitted,
it has been-
and submission
Lordship.
was that this property has been sold and the
Lordship,
application
so far as I
before
have saw the
PR
instruction, Mala, there is no talks of settlement that
Madam,
is going on, your lordship.
everything is over.
Everything is
no,
over.
everything is not over. I have been asked to deposit 20% of the auction purchase amount.
Go and deposit. How does
I
restitution
am
survive?
depositing it by this week because the auction purchaser has not been handed over the property till date. It has not been finalized. Only
Whatever.
Mala, sales certificate issued, your lordship. Mala, everything has been done. Mala, their prayer is only limited to the sale, your lordship, nothing else.
Learned advocate representing the petitioner submits upon instruction that a negotiation is going on in between the bank and the petitioner, and the bank has directed the petitioner to pay certain amount.
Yes.
Which the petitioner intends to pay by this week.
Yes.
Paragraph. Learned advocate representing the bank submits upon instruction that the sale is complete and sale certificate has also been issued. Stop. Paragraph. As the present facts are not averred in the writ petition and the prayer made in the writ petition appears to have become infructuous, accordingly, the writ petition stands dismissed.
Grateful to your lordship.
Lordship, Lordship, on last occasion I appeared on behalf of the state and my name has been wrongly recorded.
Wait, don't give that. I have a copy. Warner Roy Chaudhary.
I am state, my lord.
I'm for the bank, your lordship.
Amrita Tiwari. It has been written as Auditra Tiwari.
Oh, it should be Amrita Tiwari. Please correct it. Pradeep.
Supplementary.
Yes.
Number 11. State your lordship.
I am appearing for respondent, private respondent number 8 to 12 and 15. I am filing one supplementary affidavit. Receiving the complaint of the petitioner, my lord, the petitioner received a letter from the district magistrate. The proceeding has been initiated and steps may be taken up. This is the forwarding letter. What happened in this?
So the relief that you were seeking has been allowed.
Yes, that is the proceeding initiated.
Lordship,
Proceeding be concluded.
may I indicate one thing? If your lordship kindly take pen to come to the report once, my lord. What
Which report?
that report, that letter which they have filed by way of supplementary affidavit.
Otherwise,
Yes,
they
ma'am.
have forwarded.
18th of July?
18th of July.
Yes.
Your lordship. Lord, if your lordship can take pen to, that is a letter received by the grievance cell district magistrate such and such, submitted by Samapada Bhumi. Lord, this letter does not indicate that, my lord, this application has been taken care of, or not. If your lordship can,
If the petitioner says his grievance has been redressed,
I'm just indicate, my lord. Yes.
please come. Learned
Lordship, this
advocate
is the
for the
report.
petitioner submits that.
May I have a copy
That
of that, your lordship?
the grievance of the petitioner has been redressed as the district magistrate Purva Mednipur has already taken steps to consider his representation. In view of such submission, there is no requirement of keeping the writ petition pending. The same stands disposed of. The respondent authority shall take steps to conclude the inquiry proceeding in accordance with law at the earliest.
Lord, giving the opportunity of hearing to the
Giving opportunity of hearing to all necessary parties.
Within certain period.
At the earliest, it is the allegation. What is the allegation?
Lord, they are alleging that
and digging of the
Lord, if
plot
you,
beside the petitioner's land.
yes,
Oh.
Lord,
At the earliest point,
and that
but
is already
possibly within a period of 8 weeks from the date of communication of this order.
Title suit pending also, your lordship.
Lord, there are two title suit pending. Lord, they are fighting there, no injunction, nothing. Lord, let the report be served upon us, Lord, so that Lord, we could
Give
consider.
to both parties. To both parties.
Grateful to your lordship.
Grateful, your lordship.
Item number, lordship.
Item number 13, I am appearing
In
for the
item number
respondent
13,
enforcement director.
lordship. Lordship, in item number 13, Mr. Devabrata Roy is appearing for the petitioner.
12 নম্বরে ফাইল কোথায়? 12
Lordship, in item number 13, Mr. Devabrata Roy is appearing for the petitioner. He could not come due to high fever, your lordship.
will
Praying
kindly
for or not today.
Take the prayer. This is
A learned advocate is suffering from high fever. Even then, I'll go through the press.
I stand corrected. I tender my apology.
Possibly, last petition, there was a restriction upon the petitioner to serve a complete copy of the writ petition.
I have been
Not
served.
served.
I have been served. I have been
Private
served. day
response.
before
I
yesterday.
shall
Petitions are not there in my writ petition.
I shall communicate him that. I do not know about it, but I shall communicate it.
Please do. Not today.
May I pray this matter on any other date,
Tuesday,
barring next week?
barring next week, following week.
ওই জন্যই তো 4-5-6 week
Ninth.
আমি না বললাম
9th.
9th.
List the matter on 9th. তার আগে লিখে দিন, accommodation has been sought for on behalf of the learned advocate for the petitioner. List on 9th.
Deeply obliged. Appearance to the
May please your lordship. So this is that matter where the petitioner, being a lady, was restrained from traveling abroad. On the ground, no notice has been served, nothing has been served. When immigration department stopped, I inquired, they told me that I was once a director of a company in 2011. Now that company has defaulted in paying some loan. So I will not allow you to travel because there's a LOC notice. Now challenging that this issue is settled by at least 4 judgments of a Calcutta High Court that you cannot restrain someone from exercising fundamental right. Even if he once is a director of a company, if money is due, you initiate recovery proceedings and get a decree. Now, this is a settled law. Now, when I filed this writ petition before the division bench, an order was passed on 29th of October 2024.
You filed the writ petition before the division bench.
No, sorry. Vacation bench, sorry.
Vacation.
Vacation bench. So 29th October 2024, order passed that my demand justice you kindly consider within a particular period of time. Now, it was kept pending, no notice given. We inquired, kindly give us a hearing as per the High Court order. No reply. 1 month has gone by. And last occasion, Lordship took up the matter. My learned friend was not present. The Lordship says that give them a notice. We serve them a notice. Now, after receiving the notice, kindly see the ploy only to delay the hearing of the matter. Now they have given us a notice on 28th of November 2024, yesterday, that since our schedule was very busy, we could not give you a hearing. I will give you a hearing now in the month of December at 9 p.m. So this is the ploy. Kindly see. Order passed on 29th of October 2024. Kindly see the ploy only to delay. I am only pressing today for an interim order that kindly allow me to travel. Let them consider my representation on demand justice, but I should be allowed to travel.
Hearing has been given. You attend the hearing.
No, not
Without
given.
attending the hearing, you'll go.
No, they have not given a hearing. 29th of October 2024 order passed. Hearing was
Now date has been fixed.
They had to give us a hearing by 15. They have to decide by 15. Kindly see the order of 29th
I wish to
October.
inform that opportunity of hearing will be provided to you during the first week and your response will be considered for the disposal of your representation. Please come.
After we have given them a notice that you kindly appear, now they have only to delay the hearing of the writ petition.
I beg to appear on behalf of the respondent bank.
You are for the respondent bank?
Respondent bank, Your Lordship. Lordship, I tender unconditional apology because I miss out on the last occasion when the matter was taken up for hearing by Your Lordship. But the Lordship, from the record, it perused that earlier the matter was taken up for hearing by the coordinate bench of this honorable court in vacation bench. At that relevant point of time, the coordinate bench was of the opinion that since the medical agency has pleaded in the writ petition after perusal of the materials on
Did
the
you file your wakalatnama? Tell me first.
Yes, yesterday.
When?
Yesterday.
And all these dates you appeared without a wakalatnama?
No, only one day during vacation. And last date I missed out. I tender unconditional
Last
apology.
paragraph of the order.
There was Lordship, my only bank has ready to give him an opportunity of hearing.
That's a ploy. After notice has been given.
Learned advocate representing the petitioner produces an email communication made by the bank mentioning that an opportunity will be provided to the petitioner during the first week of December 2024. And her response will be considered for the disposal of the representation in accordance with law. Stop. Paragraph. The bank is directed to immediately fix up a date of hearing and dispose of the representation of the petitioner at the shortest possible time. Stop. Final order shall be passed positively by 31st of December 2024. The writ petition stands disposed.
Your Lordship, only one thing. Kindly keep it pending. If Your Lordship looks at the last order, why I say so? Why I say kindly look at the last order, because if they today pass an order giving a fresh cause of action, I will again have to file a fresh.
You have to.
Your Lordship, this thing is that the grounds remain the same. They have to consider my representation.
How do you know how they dispose of the representation?
My demand justice, let them
So
consider.
we are considering.
Your demand justice they will consider.
Within the scope of the writ petition, let them pass an order. Kindly keep it pending.
Sorry,
Because
sir.
Your Lordship, this issue is very much settled. Issue is settled by the Calcutta High Court in various judgments.
Achha, it will be open for the petitioner to produce all documents, including relevant decisions in her favor at the time of hearing.
Lordship, obliged.
My lord, in this case, I am for the Union of India, my lord. Along with Amrita Pandey.
I only pray for one indulgence.
Record the appearance of the Union of
Grateful, my lord.
Vacation time, my client intends to travel to USA for medical purpose. If Your Lordship kindly direct them to dispose it by 15th of December, so that in the meantime I get the time to at least challenge it. so that I can at least travel, because this issue is
So why
settled.
he is apprehending? We
Issue,
are considering
I am
his
apprehending
presentation.
because he will reject, I know.
We are not
Issue
reluctant.
is settled
Why
by
should
5 judgments of Calcutta High
If
Court.
we find there is certain
Kindly ask them to dispose it of by 15 so that I
why
can
is
at least-
apprehending?
I
On
can at least take
apprehension
the
note can
chance
be passed.
to travel during the winter vacation.
The order is at the earliest, shortest possible time.
Obvious.
Outer limit is 31st of December.
They will not do it before 31st. Your lordship also knows.
They will?
Your lordship also knows that they will not do it before 31st.
Why?
because
On apprehension,
State Bank, your
presumption,
lordship knows,
assumption,
otherwise they
we
would
are
have allowed us
considering
to
his
travel.
representation. Why
Anyway,
is
please call
apprehending?
the next matter.
We are considering his representation. Obliged, your lord. Obliged.
Lordship, item number 15, my lord, I am appearing for the district judge. My lord, there was a direction to file a report, your lordship. Report has already been served and circulated.
I appear for the petitioner, but there has been a development in this matter. There has been a development in this matter. Madam, may I just hand up an order passed by the Honorable Division Bench taking up Ponzi matters? Madam, I do not know for what reason the court was apprised that this petition is pending before this Honorable Court regarding transfer of cases from one special court to another. Madam, the Honorable Division Bench, if your lordship kindly take, Madam, we were not even parties to that case. Kindly take from paragraph 12 onwards.
Yes.
এই যে- না না 21-11 জয়মালদা বলেছে আমি নেবো। এখানে তো হবে।
Please come.
Yes.
Thank you.
Well, only one
The
submission,
order
lordship.
dated 21st of November 2024, passed by the Honorable Division Bench in a batch of writ petitions, first of which is WPA 27005 of 2016, along with several cans. Has opined that the present writ petition is required to be taken up by a bench dealing with Ponzi matters. Stuff. In view of the above, the instant writ petition stands released from the list of this bench.
Would your lordship record our submission?
Very well.
My lord, and I have
kindly
also,
record
my lord,
my
the district
submission,
judge and registrar has also filed a report.
Madam, may I just
One minute.
Yes.
দেখে নিন না কার রিপোর্ট আছে
এটা district judge and registrar.
পেছনে লেখা আছে বাক্সে
পড়িয়ে নিচ্ছি।
Registrar City Sessions Court is
Lordship.
here.
And the district judge.
बात कॉल कीजिए
It has been circulated.
আচ্ছা এইটা কোথায় এইটা all right very well and you are filing it for whom?
I am filing it for the district judge and the registrar of the city sessions
এইটা
court.
তাহলে সেম জিনিস are there two reports separate?
No, no, madam.
Lordship, there are two separate reports, one by the High Court administration
Registrar
and
High Court
have not
কোথায় তাহলে এটা
The
হবে?
High Court administration report has not been forwarded to us.
কালকে ওনাদের অফিসে ওই মিছিল ছিল না ওয়াকফ বোর্ডের বলে সব ল এন্ড অর্ডার সিচুয়েশনের জন্য সবাই চলে গেছিল আজকে আসতে বলেছে তো আপনাকে জানিয়ে দিচ্ছি বিকেলে
আমি
হ্যাঁ, হ্যাঁ,
দেখে নিন একটু কে কে দিয়েছে সেটা রেকর্ড
হ্যাঁ। অমৃতা বলে একজন দুজন আছে অমৃতা অমৃতা এরা
Thank you.
Other respondent, let him say.
You are for the
Respondent, madam.
My lord, I have
Respondent?
petition.
Yes, Lord.
I appeal for the
Respondent,
number 5 and 7. Chinakuri coal mining matter, lordship. Chinakuri 3 coal mining.
Yes.
Lordship, that your lordship was pleased to direct them to file an affidavit disclosing the fact whether it is closed or not. Now,
Yes.
affidavit has come, lordship.
Well, may I file the affidavit?
And
Yes.
in the view of this affidavit, lordship,
For the
Track Miller, because he is the authority, Miller.
Proposed. Proposed.
Miller, I have given.
Now you've separated? Oh, separated.
I have two fold of submission, Lordship, then your Lordship passes an order, whatever your Lordship. Lordship, kindly come to page 2 of the affidavit submitted by my learned friend. Your Lordship was of the view that they will come up with a affidavit stating that whether it is operational or not. Paragraph 3, it says, it's stated, as stated by the petitioner, that as per guidelines of the Ministry of Coal and tender was issued for reopening, development and operation of Chinakuri UG discontinued coal mine on revenue sharing basis. But the petitioner has referred only point number 6 of the said order. In fact, the high-level committee formed by Niti Aayog has duly recommended that Coal India may consider the outsourcing of non-operational and loss-making mines through open bidding process on revenue sharing basis, as already has been undertaken by the Ministry of Petroleum for outsourcing the well fields of ONGC for the mines which have been discontinued but have sufficient mineable reserves at suitable depths. Steps should be taken to extract deeper reserves. Now, Lordship, they themselves also says that 6 was there and we have referred 6. Rest of them are not part of this document. Now, Lordship, I have not challenged the policy of the state regarding this. I said they are not working within the parameters framed by them. Now, Lordship, kindly come to paragraph 4. I state that Chinakuri 3 mine is a loss-making mine. The purpose of this document was to hand over the mines to MODs, those mines which were non-operational, which were abandoned, and which are closed. Now, Lordship, I was looking for the meaning of abandoned, discontinued, and closed mines in terms of their own memo. So, Lordship, kindly refer to the memo dated 28 October 2022.
May I get a copy? আচ্ছা ঠিক আছে আপনি পড়ে দিন।
My lord, it says the categorization of the non-operational mines. Now, what is the play here? Discontinued mines. Discontinued mines means such working in the mine as have been discontinued for a reason and there are inaccessible or rendered inaccessible but are likely to be worked again. These mines can be reopened as per provision of such and such. This is not a case of discontinued mine. This mine was continuing. Even their document says so. Abandoned mines, this is also not applicable here. But closed mines, it says the closed mines are those mines for which the owner, agent, manager has submitted notice for closure in prescribed format under CMR 2017 Regulation 5 to the Chief Inspector of the Mines, Regional Inspector of District Magistrate, and has also obtained the mine closure certificate from the coal controller. However, prior to implementation of the mine closure guidelines 2009, closed mines may be considered as those mines for which the owner of the mine has already submitted a notice to the Chief Inspector of Mines, Regional Inspector, and District Magistrate. Lordship, in my humble submission, Lordship, I submit that this was a case of, it is not a case of closure. If it was a case of closure, they wouldn't have transferred all the employees. They would have taken the route of this by closing the mine. So, Lordship, this is the state. Their affidavit clearly says that mine was operational till October in terms of production. Kindly come to page 33. This is the Delhi production report. Lordship, kindly refer to the this coal UG department. This actual was given, target was 0, actual was given. And Lordship, this becomes totally nil afterwards, since November. November onwards.
24th October 2020.
24th October onwards,
2024.
There was no production in terms of the extraction of the coal. And they issued the notice of transfer. So, Lordship, what was my case was, this is not the direct way which they could have done. I know your lordship's constrained to interfere with the policy, but they should do it within the parameters of the their own policy which is framed. Because of that, I cannot challenge the transfer. And number two, lordship, since we are the workmen, let it be disposed of the guidelines direction that we can avail the other routes regard to protect our own rights as the employees. These two are the twofold submission, lordship, I can make. Then your lordship may pass the.
What is the other route of protecting your right? They say they are not throwing you out. They will transfer. They have already
Everything would be protected.
Already done.
already
Everyone
done.
is protected. Everyone has accepted it. They have gone. Milad Chinakuri Milad 3 Milad SIM. It's situated within Milad Chinakuri 1 and Chinakuri 2. Milad 3 SIM is in between. Milad there is Milad a guideline Milad is issued by the authority DGMDS Milad, which says Milad that Milad for the purpose of vertical SIM Milad, the entire SIM is to be given because it has to be cut Milad, like it's a layer of a cake Milad. First layer, second layer, third layer. If it is not vertically given Milad, there are safety issues. I have the regulation, I'll cite it. So Milad Chinakuri 1, which has the best SIM Milad in Milad entire Asia Milad. That is the natural resource Milad which has to be taken out. That's similar ECL Milad things Milad they have to take out because lordship knows there was Coal Nationalization Act 1971 that has been Milad diluted by the Act of 2018. That Milad, it's the minds of ECL. They can do it as they like. There is no policy there. These are Milad government orders they are showing Milad. Now Milad, because I have to take out that high Milad quality of coal, which is Chinakuri 1 Milad, which is in the bottom Milad, and Chinakuri 2, which is on the top, and this fall in between Milad. These two are two discontinued mines. So as per the guidelines of the mining guidelines, Milad, the vertical seam, entire 3 has to be given to one contractor. So Milad, he has to take it out because the safety norms in, and Milad, giving Milad the seam on a horizontal norms is not permissible under the Act. So for Milad, my learned friends, locus. So far as the learned friends Locus is concerned, Milad, he is an ex-employee. Milad, he has
Ex-employee.
ex-employee. Milad,
Not an
2
employee.
are ex-employee. Number 3 is an outsider. They are occupying the quarter of ECL. Eviction proceedings
Those
are there.
has to be done in accordance with.
Please. I did not interrupt you, so I never do that. Now, Milad, kindly, Milad, takes the. They are ex-employees. So far as the employees are concerned, there are 500 odd employees. The employment clause says I have to transfer them. They cannot challenge the transfer, despite some made some issues. So, Milad, I considered that and gave him posting to all the mines. It are not Milad, the employees are Milad without their livelihood. So far as 28, they're sleeping employees. They do not come. When they come and approach us, I'll take appropriate steps, Milad. Why in this late hours, Milad, when Milad the tender is of 2002, Milad, there should be interjection today. 22, Milad, there should be interjection today, Milad. Milad, I am led by Mr. Mukherjee, Milad. He may have something to add.
Madam Millard, I just very briefly, Millard, just 2 minutes, your lordship, give me. Millard, the persons who have filed, Millard, which is very important, Millard, because after all, the writ jurisdiction, Millard, is an equitable jurisdiction. Persons who have filed, Millard, 2 of them are ex-employees, 1, Millard, is an outsider. All 3 in possession of Millard, the Millard staff quarters, who Millard have Millard are staying on, and Millard, while Millard proceedings are pending against them. Millard, they Millard really do not have any locus at all. Second, Millard, 502 employees, Millard 479 have Millard left and Millard joined Millard wherever they were asked to. The balance Millard 23, the balance 23 Millard have Millard are long absentees. Millard, they are Millard absent quite often. They have not come forward and Millard made any grievance. But Millard, they continue to be employees. So Millard, there is no right of theirs, Millard, which has been affected. And third, which is very important here, as on date, Millard, there is no production at the mine. We've given Millard the details. There is no production. And importantly, Millard, here, Millard, for 3 of the mines in the group, Millard, the seams overlap. So if there cannot be a vertical partition, Millard, horizontally, Millard, there cannot be, Millard, just Millard being given, Millard, in Millard pieces. Because that is, Millard, a safety hazard covered, Millard, by the regulations.
I have the regulation.
Millard, I have the regulations. It's quoted there, Millard, in our affidavit. So, Millard, there's no question of any Millard orders.
A report filed on behalf of
My
the,
submission, Lordship, that closure is, it is not the closure in terms of that.
the respondent numbers 5 and 7. Stop. The report mentions that Chinakuri 3 mine is a loss-making mine and has failed to achieve the target production. The respondent authority is taking steps in accordance with the revenue sharing model through the public sector participation for the development of the said mine. Stop. Service of all the employees of the mine has been protected. Stop. None of the employees raised any objection. Stop. Paragraph. The locus standi of the petitioners in moving the instant writ petition has been challenged. Stop. It has been submitted that 2 of the petitioners are ex-employees and 1 is an outsider. Stop. The petitioners are in occupation of staff quarters and proceedings against them are pending. Stop. To stall the proceeding, to stall the said proceeding, the instant writ petition has been filed. Stop. The learned advocate for the petitioners insist that the authority is not taking steps in accordance with the revenue sharing model. Stop. Paragraph. Upon hearing the parties, the court is not convinced with the locus standi of the petitioners in moving the instant writ petition. Stop. The employees of the company did not raise any objection, and accordingly, any objection on the part of an outsider cannot be accepted. The writ petition fails and is hereby dismissed.
But you only one thing, Lordship, these 3 are the secretaries of the respective unions. Lordship, kindly record my submission.
It is there in the cause title.
Grateful, madam.
এই প্রদীপ কি একটা দেখাচ্ছিল সই করার জন্য? ফাইলটা কোথায়?
Lordship, I am the petitioner. This court below is compelling me to pay unlawful payment on the maintenance petition filed with false evidence, totally false and fabricated cruelty allegations. And same cruelty allegations, the respondent also filed an FIR against me, initiating a criminal case under section 498, 406 and 34 IPC. Honorable High Court has quashed that with an observation. The allegations are vague, unfounded, and abuse in the process of court. So, Lordship, 2 items are listed in today's list. The item number 32. 32 is within the same parties on the same matters. So, my prayer is if you can club both the things, and it is on the same issue. The first petition was.
First petition is of the year 2022.
Because
and
the.
Next is of the year 2024.
That is 32 is the petition.
Did you serve notice?
Between the same parties.
Did you serve notice?
Yes,
to
yes.
your other side?
Yes, yes.
Where is the notice? When was it served? This is in connection with item 32.
32, yes.
We are in item 17 now. Where is the notice of
That
17?
was served in the time, it was, long sessions were there. It is, you see the status report.
Please come. Let this writ petition appear along with WPA 25207/2024.
Lordship, so many hearing was
In
there.
bracket Shubham Roy Chaudhary versus State of West Bengal and another. Stop. Let notice be served upon the respondents. List on 6th January. এটা কিন্তু হবে না, এটা অন্য মামলায় 32-এ।
This notice
32-এর ফাইলটা এর সাথে ট্যাগ করবেন। আছে? তাহলে 32 একটা অর্ডার লিখুন তো। On record. List along with WPA 19102/2022. ঠিক আছে? Let
This for
notice be
256.
served upon the respondents.
ছয় তারিখে থাকবে দুটো মামলা একসাথে।
6 তারিখে?
হ্যাঁ, দুটো মামলা একসাথে।
6th of January. আচ্ছা আচ্ছা।
ঠিক আছে।
These are the impressions.
অ্যাডভোকেট অন রেকর্ড আপনি?
Yes,
হ্যাঁ হ্যাঁ, ঠিক আছে, চলুন স্যার। Well, at 18, I appear for the petitioner. This matter relates to West Bengal Public Land Eviction of Unauthorized Occupants Act 1962. Well, section 3 and 4 should be invoked. I have made an application before the district magistrate. Well, that has to be acted upon page 11.
Who are you?
I am the landowner. My lord, ingress and egress of my property is being obstructed by the private respondent's property, my lord, construction. That construction is at the land of the government. Therefore, that should be removed by the government.
Any instruction? This is a representation of 2022.
Yes.
I'm here to get the instruction, my lord.
Can you dispose of for any?
My lord, if it can be remanded back to the DM2 for.
Please come. The petitioner's representation seeking removal of unauthorized occupants from government land who are blocking the ingress and egress to the petitioner's property is pending consideration for a considerable period of time. Stuff. Without going into the merit of the allegation of the petitioner, the instant writ petition is disposed of by directing the district magistrate and collector, Murshidabad, to take necessary steps to consider and dispose of the representation filed by the petitioner in accordance with law after giving reasonable opportunity of hearing to all the parties and by passing a reasoned order at the earliest, but positively within a period of 8 weeks from the date of communication of this order.
And the consequential steps has to be taken. My lord, section 4 says.
Let reasoned order be passed.
My lord, section 4 says if it is collector is satisfied that public
Let that
land is.
satisfaction be recorded first.
My lord, if it is then, my lord,
All things cannot be
consequential
done.
effect has to be, my lord. Deep.
My lord, an identical, literally identical. There is it was moved and order was passed on 25th. Only there might be a, this is not regarding that electricity. This is separate.
Banana scheme.
Yes, that. And the only difference would be in this case, there is no mistake. And if I can say kindly see, my lord, paragraph number 2, their scheme was, lordship's earlier order was 165 out of 316. In this case, it is 131 out of 425. If lordship wants to check, that is at page 113.
131.
131 of 425. My lord, this.
425.
And paragraph 3, my lord, there is no part payment.
Value? Paragraph
Value, I'm coming, my lord. Value is, before value, my lord, paragraph 3, there was a part payment in the earlier matter. That has to be, there is no part payment.
Alright.
And value here, it was 247,89,447, the earlier matter. Here it is 261,82,104.
1 minute.
And there is no mistake.
1 minute. Balance payment will not be there
No, no,
because the payment due to the petitioner.
true. And paragraph 6,
1 minute, 1 minute.
sorry,
The payment due to the petitioner is rupees how much?
261,
261
82,
82
104.
104. Where do I get this page?
This page is page 126. First, Lordship, may I kindly see one completion certificate and then 126. Completion certificate is 113. Everything is identical. Basically, the Gram Panchayat
113.
is different here.
113.
113.
Yes.
Second paragraph.
Second paragraph.
Kindly see
One
that
enterprise.
131 out of 425. And thereafter, for the amount, Lordship may kindly come to 126.
131 out of 425 for the amount. For the
Kindly
amount
see
I come
126.
page number 126.
Yes, thereafter, after completion certificate.
No, but then page 113 I can see a figure, same
Yes.
paragraph. The value of supplied materials is 261,82,104.
Yes, yes, that is. So I said 261. That is there also. But Lordship in the earlier matter referred the representation page. So that's why I thought.
Page 113.
And the portion, my lord, there is a, the earlier matter, there was a mistake.
7 January 2022 signed by the Association Cooperative Societies. Director is Malda. Has been issued.
Date of completion certificate is same. But date of representation, paragraph 7 is different here. It is 29th January.
Comma 104. Your representation is addressed to the DM and the district program coordinator
Yes.
and the assistant.
And but there was no, because in paragraph 6 of the earlier order, I had one copy pasting mistake. So here that mistake is not there. So starting from though up to mention, that is not necessary, and consequential maybe language has to be little.
And the representation is dated 31st of January.
No, here representation is 29th of January.
29th. The representation dated as so made by the petitioner himself?
Yes, yes.
The representation dated as so.
All other things are my lord identical.
Copy of the representation dated 29th. Very well. চারশো পঁচিশ টাকার অঙ্কটা চেঞ্জ নো পেমেন্ট হ্যাজ বিন মেড ডিটেল রিপ্রেজেন্টেশন এটা তো ঠিক আছে রিলিজিং ব্যালেন্স হবে না the payment due to the petitioner is rupees এত এটা 126 113 পাতাতে আছে হ্যাঁ DM shall verify আর এটা ডেটটা disposed.
Well, there is one more identical, but there would be amount would be different.
This matter?
Yes, this matter.
Yes.
Yes. Lordship, may
page?
kindly see here, first change in paragraph number 2, the number of schemes, it should be 175
Page.
out of 425. This is page 116, 116.
AGM. লিখুন তো পেজ 116 স্কিম যেটা বলেছিলাম 175 out of 425 টাকার অঙ্কটা হচ্ছে এইটা amount is there in the same paragraph.
My lord, amount is different. Here the amount is
341
341 yes.
7th এটা ঠিক আছে, this is মালদা ঠিক আছে, no payment made.
No payment made. So that
yes,
Lordship, may kindly
Online, but what we have not filed in affidavit in opposition. Allegations are not admitted.
This is
But since you have not filed in affidavit, allegations are not admitted.
allegation is
I
you
have not made
made
any
payment.
allegation against you.
No, no.
One, two, three.
I know.
Allegation is you have not made payment. That is the allegation, and that is admitted. You have not made payment. So even if I record, it is not admitted. Fact remains, it is admitted.
My lord, would your lordship kindly record the affidavit services filed?
Yes,
on
yes.
record.
Service taken on record.
Deeply obliged.
Thank you.
I am appearing on behalf of the respondent. I am for the petition.
Well, at affidavit of service.
You have for the
What happened,
stated
my lord?
claims.
The petitioner's premises is adjacent to the highway authorities land. And my lord, the portion of the highway authorities land, which is, my lord, in front of my premises, my lord, it is covered by way of constructing the Paka structure. And therefore,
By whom?
By the private respondent. And therefore, my lord, the petitioner's ingress and egress is totally blocked. And therefore, my lord, petitioner made a representation before the authority, that is Annexure P3, that is Assistant Engineer, Bosirhat Highway Subdivision. And my lord, it is not considered, and therefore, my lord, the petitioner has come before your lordship for necessary direction upon the Assistant Engineer. Lord, as per section 10 of the Highways Act, my lord, the authority can proceed the.
Any instruction?
My lord, I am taking instruction from the assistant engineer of Bosirhat Highway Division. My lord, matter is pending before the respondent number 3. My lord, kindly.
District magistrate.
My lord, petition statement absolutely correct. My lord.
The TMC party office is also there.
I don't know, my lord.
You are
As per report, my lord.
Yes, yes. As per report, it is there. Acha. The petitioner prays for removal of the unauthorized encroachers of government land. Stop. The assistant engineer paragraph the assistant engineer, comma, Bosirhat Highway Division, comma, PWD within bracket Roads Directorate has forwarded instruction to the learned advocate signed on 3rd October 2024, mentioning that as per the demarcation of the government land made on 15th of July 2024 and the report of the Blockland and Land Reforms Officer, comma, Bosirhat -Roman 2. Encroachers have been found in front of encroaches have been found on the government acquired land on LR plot number 1972, Mauja Kakra, jail number 18, PS Matia, district No.24 Parganas, in front of plot number 1971, Mauja Kakra, jail 18, PS Matia. Stop. Notice under section 10 within bracket 1 of the West Bengal Highway Act 1964 has been issued to the encroachers, but the encroachers are yet to be removed. Stop. Along with the private respondents, TMC party office has also been found to be one of the encroachers of the subject land. Stop. Paragraph. The assistant engineer is directed to আপনি লিখুন the district magistrate, মুর্শিদাবাদ is directed to মুর্শিদাবাদ না এটা হচ্ছে not 24 Parganas, not 24 Parganas is directed to take prompt necessary steps to remove the unauthorized encroachers encroachers from the government plot of land in accordance with law at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. It will be open for the district magistrate to take the assistance of the police for the purpose of removal of the encroachers. It petition disposed. Report is taken on record. Service taken on record.
The petitioner, next two matter almost my lord same, but my lord authority is separate, my lord. It is my lord highway authority, Tomluk highway subdivision.
Any report?
But we have already got for information from the block land and land reforms officer, my lord, with the for demarcation. And my lord, we have to, my lord, initiate proceeding under 10.1. Your lordship knows, my lord, 10.1, my lord, after providing opportunity of hearing, my lord, we will pass order and aggrieved party, if necessary, my lord, can prefer an appeal before the district magistrate.
That is different.
Now 10.1, my lord, we will dispose of the proceeding within certain time, my lord.
Please come. The petitioner prays for removal of encroachers from the government plot of land. The representation filed by the petitioner is pending consideration. Before the executive engineer, Tomluk Highway Division. Stop paragraph. Learned advocate representing the state respondents relies upon the instruction forwarded by the assistant engineer, Tomluk Highway Subdivision, PWD Roads, dated 5th of July 2024, which mentions that the Blockland and Land Reforms Officer Shohid Matongini Tomluk within bracket Chhatro, Purba Mednipur has been requested for early demarcation of the government plot in front of the Rayati land of the petitioners. Stop. Next. From July, nothing has been done. We are in the end of November.
But can it direct within certain time?
Next. There is no further report as to whether the Blockland and Land Reforms Officer has taken steps for demarcating the government land. Stop paragraph. In view of the above, the instant writ petition is disposed of by directing the Executive Engineer, Public Works Directorate within bracket Roads, Tomluk Highway Division to take prompt necessary steps to remove the encroachers from the government plot of land in accordance with law at the earliest, but positively within a period of 12 weeks from the date of communication of this order.
But, only one line can you add, my lord. If the BLRO have not forwarded, can you direct them to forward within certain time? Because the government official, he is saying they have not supplied, they will say, I have not received.
The aforesaid officer shall ensure that the subject plot is demarcated forthwith for the purpose of identifying the government land. Writ petition disposed. Instruction written with the records.
Good.
Next matter, my lord, analogous matter. Same plot, my lord, same authority.
Is there any instruction
Lordship, from the police, I am getting instructions.
from the police?
Police,
Why not from the land authority?
I'm not getting instruction. From police, I am getting instruction, but land authority, I have not got any instruction.
Did you seek for instruction
Lordship, I sent radiogram to the department.
to the
That all the concerned, my lord.
all concerned? But in the other matter, Mr. Mukherjee could get the instruction and you couldn't.
Because
Same plot, my lord.
Same plot.
Same
PSI,
plot.
Tomluk PSI.
Same plot, same authority.
সেম অর্ডার হবে, শুধু ওই ইনস্ট্রাকশনের পোর্শনটা থাকবে না।
Grateful.
24, your lordship, appearing for the petitioner, your lordship, I've once again served upon
I'm led by Mr. Rajdeep Mojumdar. He's on his legs in courtroom number 8.
Who is he appearing for?
Union of India.
Yes. Who is assisting him?
Mr. Kundalia is appearing for the respondent custom authority, but he is appearing before court 759. Kindly give short pass over.
My lord, not today.
Lordship, this matter I've been mentioning on many occasions, your lordship. I'm being constantly harassed at the hands of the customs authorities.
Kindly give short pass over.
I'm praying for not today, my lord.
We are ready with the brief.
Lordship, may I indicate the matter, your lordship?
No.
Lordship.
The request for not today is there. What can be done? Not today. Come prepared on the next day.
Lordship is keeping the matter for Monday.
Yes, only not today.
Grateful to your lordship.
This is the service and mentioning notice, my lord. Actually, the petitioner complaints of the inaction of the Central Vigilance Commission, my lord. He has registered a complaint which has been registered.
1 minute. Who is for the Central Vigilance Commission?
The complaint appears at page 73, my lord. Thereafter, as nothing was forthcoming, a reminder letter was forwarded to them, which is starts from page 79, my lord. Those have not been disposed of yet. The only prayer of the petitioner is.
Who are you?
But I am the applicant.
Applicant means, are you related with this bank or anything of that sort?
My lord, I was an employee of that bank.
You were an employee.
Employee, there was a dispute with regard to the seniority, as
Yes.
because two entities, there was a merger. I was from the entity which got merged with another. Now I was at the post of AGM, which was under grade 8 of the earlier entity. Now, as because it ceased to exist after the merger, now a promotion was accorded to me, which was in fact a demotion. Because from AGM, I was posted to another, when as per the existing rules, I could have been only promoted to the post of GM or DGM. But that was not done. So I had made the allegations against them that these were not being considered. You are flouting the laws of the merger also, because the merger contains a specific clause that.
No, so what has Central Vigilance Commission got to do with it?
Because of the vigilance angle comes into the play, because this has been done time and again, and on the basis of my complaints, nothing was forthcoming. But because of my complaint, a departmental proceeding has been initiated against me.
Against you?
Yes, for making complaints. That is why I want this to come to light, that my allegations should be
Who
proved.
is the, apart from the commission, who is the, where are you employed?
IDBI Limited has not been made party, my lord, in this case.
Because the allegations are.
Where are you employed now?
Now I have retired.
You have retired?
Yes, now because.
Where did you serve?
IDBI bank.
IDBI is not a party?
Not a party, my lord, because my grievance is with regard to the complaint which is not been. They have registered is. They have acknowledged it. They have returned. Kindly see the last page. They have acknowledged. They have forwarded letter to me, but that is not being disposed of. That is the grievance of the petition. Kindly see the last page. Page 86. They have taken cognizance of it. They have registered the complaint. They have forwarded it to me that we have forwarded such and such, but till date nothing has transpired. And in the meantime, I am facing the disciplinary proceeding, even after my retirement.
You think if they consider this,
My lord.
you will be relieved of the disciplinary proceedings? That is not?
No, because my allegations, that whatever allegation, what are my substance, I have documents to substantiate my allegations. I have attached those documents here also, that there is a specific clause in the merger agreement.
I still do not understand how vigilance comes in over here.
Because
there must be some seniority dispute between the employees of the organization.
My lord.
There must be a senior ranking officer who is to deal with it and dispose of.
My lord.
Why you go to the vigilance?
Because they have not disposed of. Because I have made application before the CEO of the bank, Central Vigilance Officer of the bank. Nothing was forthcoming. Now against these persons, because those persons who are at the helm of IDBI, they are involved in this. That is why my recurrent complaints are not being acted upon. That is why I had to make allegations
What is your
against good
submission?
officers, against the vigilance.
My lord, his dispute against his promotion.
Yes.
But that matters he has not challenged. Now she made complaint before the Vigilance Commission, alleging, my lord, never has been disclosed that there is some promotion not with seniority. That is look into the Vigilance Commission will inquire. That is it. Initially his, my lord, complaint has been closed. Page, my lord, page 66.
See, the commission says it has been sent to the CVO, Central Vigilance Officer of the bank, for necessary action.
Action, but my lord, if the
Bank
vigilance
is not made
registers a
party.
complaint, my lord, subject to a lordship correction, the vigilance registers a complaint, my lord, I may be afforded an opportunity of hearing before whoever deals with it. Nothing has been forthcoming. I am not being made. I have not been asked to submit documents. I have not been asked to meet this person. This person is going to deal with your complaints. This is a thing which is going on round and round that they are forwarding. Even previously, the complaint which my learned senior friend referred to, that complaint, the vigilance raised a note
Is
that
the
yes, there are
vigilance,
some
tell me
discrepancies.
whether the vigilance has the authority to
Yes,
look
my
into
lord.
this
After
seniority
the-
dispute?
With regard to the discrepancies, with regard to malfeasance in the bank, as per the RBI
As
circular,
of now, you were only restricting your submission to seniority.
my lord, but seniority is being deprived to me by affording that opportunity to others. That is my case.
Can the vigilance authority look into the issue of seniority?
Well, the seniority, my seniority is being deprived. What is the reason? The reason is somebody is being.
You are not following, or I am unable to understand you.
Look, the allegations are of corruption. That is why I am being denied. Somebody else is being favored from the merged entity. And as because I am from the transferor entity, I am not being promoted. That is my allegation. I am being denied.
When did you retire from service? It must be there in your list of dates.
He has retired from 2019.
2019, we are in 2024.
Well, the allegations of this first complaint was in 2016. That is
right. Assuming it was in 2016, why the writ petition in 2024 has been filed?
And nothing was communicated to me.
And so you will wait. So you still keep waiting.
Well, I preferred RTI. In RTI,
Whatever you do,
they have replied to us in 2024. In 2024, they have replied that these are the persons who have come to a conclusion.
What will be your answer if the court is thinking of the view that only for stalling the disciplinary proceeding that is pending against you, you are coming up with all these things?
That is independent. I want nothing with that. But I want my complaints to be addressed. Because for making complaints, I am being penalized. But my complaints are not heeded to. And my case is similar, that there is a clause which is being violated. And somebody else is being favored. And I am being made the scapegoat just because I made complaints before the officers.
Please come.
These can be looked into by the vigilance.
The petitioner claims to be a retired employee of ITBI Bank. Stop. He retired from service in the year 2019. Stop. He has raised certain issues with regard to discrepancy in his seniority list. Stop. It has been submitted that because of corruption, his seniority has been deliberately altered. And instead of a promotion, he has been demoted. Stop. The petitioner lodged complaint before the Central Vigilance Officer in the year when?
So the last one is a 2024.
First occasion.
First occasion is 16. 2019. First.
After retirement?
Yes. Before retirement. While I was in service, I had made the
application.
When Milord retired, Milord, that has not been mentioned, Milord.
While he was in service in the year 2019. Stop. The petitioner submits that proceeding has been initiated against him for lodging complaint before the Vigilance Commission, but the Commission is not taking any steps to dispose of his complaint. Paragraph. The petitioner prays for a direction upon the Central Vigilance Commission to dispose of the representation filed. Paragraph. Upon hearing the submission made on behalf of the parties, I am of the opinion that the issue relates to certain service dispute of the petitioner. Stop. He retired from service in the year 2019. Stop. Complaint was made while he was in service. Stop. The instant writ petition seeking remedy has been filed in August 2024. Stop. At such a delayed point of time, the prayer of the petitioner seeking consideration of his representation relating to his service dispute cannot be allowed. Stop. The writ petition accordingly fails and is hereby dismissed. Stop. Dismissal of the writ petition will, however, not stand in the way of the Central Vigilance Commission to take steps to dispose of the prayer of the petitioner in accordance with law.
Subject to lordship correction, the present writ petition concerns a 2024 complaint. That is in connection with the 2019 one.
No further matter will be taken up. একটা লিভ দিয়েছিলাম না একটা লিভ দিয়েছিলাম
Lordship,
Yes.
Lordship, may I only indicate, Lordship, item 24. Lordship has been pleased to keep it on Monday. Lordship, Monday is taking us to the monthly list. Lordship may very kindly keeps it on Tuesday.
Tuesday.
Grateful, my lord.
Yes.
My lord, I
The
have,
figure.
yes, my lord, I have taken instruction, my lord. There is a due of rupees 16,28,127 as on date, my lord. This is
When
the
will you
state.
pay?
My lord, already we have paid 3,70,000 before the petitioner was affected by Karsananama, my lord. For 1 year.
So you will not pay?
Yes, my lord. We
When?
have agreed, my lord.
When?
My lord, within 6 installment, I will clear entire the due, my lord.
No. Otherwise, I'll proceed.
My lord,
Please come.
my lord, kindly make the installment.
The learned advocate representing the bank has placed before this court the total amount that is outstanding from the petitioner. Stop. The learned advocate for the petitioner submits that his client is agreeable to pay off the dues provided certain installment is allowed. Stop. It will be open for the petitioner to approach the bank authority for relief. Stop. The writ petition stands disposed of. Give a copy to him
Yes,
so
yes,
that
madam.
he also gets to know the
Yes,
figure.
certainly.
Disposed. 2 p.m. there are certain fixed matters. দুটোর সময় মামলাগুলো কোথায় আছে?
May it please your lordship, my lord. Your lordship's desire was that we should get an affidavit, but we have affirmed an affidavit. We had served the advance copy yesterday, and today we have served the affirmed copy. My lord, we have received the affirmed copy. And I believe Mr. Bandyopadhyay is online.
My lord, I beg to appeal.
What have you mentioned in your affidavit?
Your lordship, kindly, may I take your lordship through that? Kindly takes a look at paragraph 3, my lord. But I have indicated that in respect of the two sites, one will be completed. The two sites will be completed by 25th October 2025. And in respect thereof, my lord, I have produced annexures of bar charts. One on 25th June and the other on 25th of October. There are two sites. Kindly, my lord, turns to page 4. The lordship will find there's a bar chart. This is so far as one site is concerned, that is 25th of June. But I have indicated what all have been completed and what all remaining. The lordship will see that there are three boxes of completed.
Page 5.
Page 4.
Only
I'm
the
sorry. Your lordship
drawing
is on
has
page
been
5.
done.
Your lordship is on page 5. Yes.
Only the drawing has been done.
Only the drawing has been done. This is that work site where the jungle was. Only the drawing could be done. Nothing else. And the soil testing has been soil testing has been, so the drawing has been.
And the other one also, the foundation has also not been done. It is the load test.
The other work, I'll indicate to your lordship. I cannot say it's completed, but it's partly completed. Why? The foundation is done. What has not been done is the integrity test, which the respondents engineers do. But once that integrity test is done, we put the
Whatever.
file cap.
What is the report of the engineers?
But
My lord, I have.
your lordship calls upon Mr. Bandyopadhyay. One thing I should be pointing out to your lordship. Your lordship will kindly also have a look at, my lord, the remaining portions of that paragraph and paragraph number 4. But I have also indicated that, my lord, at every stage of this cooperation required from their engineers also, who requires to be present at the site at the relevant point. And my lord, I have also indicated that, my lord, timely payments as per the contract terms. My lord. I'm not wanting anything in excess as per the contract terms. Because, and I have till date invested whatever amount I have indicated. And till date, I have not received any payment.
What is the value of the work?
3 crore 50 lakhs odd. Both works combined.
Both works combined. Are you sure that you'll be able to conclude
Yes,
this work?
I'll tell you, lordship, why. And possibly my subject to correction, my senior learned friend was not instructed properly with regard to the drawings aspect. Why I say so? Because the drawings, the main time is consumed with at the time of preparation of the drawings. We prepare. It has to be sent to the Jadavpur University. They get back with comments. We then prepare it, send it for approval. Then we have to give it for approval before the KMDA. Now, KMDA would suggest some modifications. Those have to be reworked and reapproved by the Jadavpur University. So that takes time, which took, and we got the final drawings on 5th for approval. Those with the modifications suggested by KMDA came back on the 5th of February.
All right. Now,
This part is complete for both the sites.
What is the schedule of payment?
Yes, your lordship will kindly have a look at.
If you are not financially sound, then
I am financially sound, but your lordship will
the payment doesn't come, the work will get stalled. Right? You have invested
so payment,
only,
the contract provides for payment in a staggered manner. Kindly, may I take your lordship to that?
only 31 lakh has been invested. It's more than 3 crores. I am doubtful. I do not know what the engineers will say.
No, my lord, your lordship need not, my lord, express in it.
Anyway, Mr. Bandyopadhyay, how is your health?
My lord, I'm otherwise all right, my lord. I've done the test, my lord. Whatever it comes, it comes.
All right. Now, what is the opinion of
Yes.
the engineers?
Yes, the overall opinion is that we need to be extremely lenient to allow this person to work as I submitted. Our technical team suggests that the way the petitioner is mobilized, they will not be able to complete the work within the time schedule. But we have understood what is playing in your lordship's mind, if we have understood. And as I submitted, the intention is to get the work done. The intention is not really to penalize someone. Penalizing someone is only eventuality in the contract, consequential to the contractual clauses. Now I'll only indicate some red flags in this very short affidavit. Going by our past experiences, these few things, like in paragraph 3, if your lordship sees the 4th line, provided the release of departmental payments according to the payment breakup schedule. Then kindly take paragraph 4, 3rd line. Thus, if there is no proper cooperation from the department whenever sought for, whenever sought, it will be impossible for me to adhere to the time schedule. Then, same continuing, moreover, since I am sole proprietor concerned, unless I receive the timely payments as per the contract. Now, the contract says, my lord, I'll invite your lordship's attention to page 33 of the writ. My lord, kindly takes at page 30. Kindly gives me a moment, my lord. Clause 7. Kindly take clause 7.
I think Mr. Bandyopadhyay is referring to the second volume, page 51.
No, I am referring to page 33, clause 7. Page 33, clause 7.
Payment.
Kindly see, payment is payment of RA as well as final bill of any work will be made according to availability of the fund, and no claim to delay in payment will be entertained. Therefore, these clauses have to be kept in mind. They cannot today spring up clauses, because when this time end point is reached, they will come and tell your lordship that KMDA has not released payment on time. I have not been able to adhere. They have not given me cooperation whenever required. That is why I have not been. But we have seen this. This is going by past experiences, my lord. We are facing arbitrations because of these, my lord. I am not saying that your lordships cannot monitor a construction, my lord. I am not saying that. If your lordship feel the public law element is there, your lordships can do it. But these are, my lord, things I must point out. Along with that, my lord, certain declarations, my lord, we have found to be missing in the affidavit, my lord. If your lordship at all accepts them to finish the work, my lord, my junior has some pointers, my lord. It's not well worded, but still, my lord, I'll point out what I want to say. What I want to say is that the declarations which are missing is that they will not claim any escalation. Number 1. Number 2, they will not claim for any head office overhead at the end of the work for the extended period of work.
I
Number
didn't get
3,
it.
they will
Number
not.
number two, I didn't get it.
Well, number 2 is, my lord, what they claim, ultimately the contractors come and claim is that head office overhead, meaning thereby that my officers were in the ground for 1 year extra. So give me their salary as damages.
All right.
Under section 73 of the
All right.
Contract Act. Then, my lord, no claim for underutilization of resources, because they will come and say that my work was for 1 year. My resources were there for 1 year. But in this 1 year, because of KMDA, we could only do 7% of work. Therefore, the underutilization is to the extent of 93%. So this claim we face generally. This declaration should be there all in your lordship's order. 4th, my lord, they will not claim any interest on the security deposit for this
my lord, only one
extended
thing,
period
my
of
lord,
work.
just to cut short the matter, Mr. Bandyopadhyay need not labor on that. I have taken instructions from my client. 1 to 7, barring 6, my lord, we are agreeable on all.
You have a copy?
Yes.
Oh.
1
Yes,
to 7.
6 has to be there, because if they do not adhere to the timeline again, we will have to impose the LD. We cannot go by to clause 2.
I join issues only on account of it.
And my lord, my further submission on LD will be that this LD that we have imposed, my lord, allowing them to work should not curtail our right to impose LD. It may get deferred. Because, my lord, otherwise we have no way to penalize a contractor. They will do anything. They will stop the work at any cost. And, my lord, I have one more submission to make, my lord, on the timeline that they have given. My lord, if your lordship has seen paragraph 3, but these are the declarations that should be there. That is one part of it. Second part is the timeline, actual timeline. Kindly take paragraph 3. Firstly, my lord, they have bifurcated a single composite work into 2 parts. Very well. I will go by their bifurcation. There was no bifurcation in the contract. 510 cubic meter work will be done on 25th of June, paragraph 3. And 640 cubic meter will be completed in 25th of October 2025, according to them. This bifurcation is not there in the contract. It's a composite work. Anyway, taking their bifurcation, my lord, now kindly takes page 174 of the writ petition. This is their last letter praying for extension of time.
Yes.
Well, kindly take the last paragraph. This is a letter dated 4th of October. This is the ground reality according to them on 4th October. Kindly take the last paragraph. In this regard, we also declare that we will complete the said work in all respects by 31st of March 25 for 510 cubic meter and 30th June 25 for 640 cubic meter ESR without any fail. So as on October, they needed 9 months according to their assessment. Now, my lord, even going by Mr. Gupta's submission, according to because of our fault, they have lost 1 month. They were before this honorable court, they have lost another month. So 2 months are gone. So even if we start from 1st December, they should still need 9 months. 9 months will take us to 31st of August. So, my lord, the end date should not, they should not suddenly get 2 months extra because there is no change in situation. And I'll tell you lordship why the contractor has wanted up to October, because the puja month will be there. He wants to take advantage of that time because his laborers will go home. These are normal reality, my lord, we face everywhere. So, my lord, if on 4th October they said they will complete the work in 9 months, from 1st December they should get 9 months to complete the work by 31st August. For 510 cubic meter, it should be within 30th of April, and for the next part should be within 31st of August, according to their timeline. 4 months for the first part, 4 months for the next part.
But your lordship will kindly appreciate that Mr. Bandyopadhyay is wanting these declarations bound by no escalation, no interest, overhead, no overrun cost. So we will not gain by delaying into. Not all we wanted to indicate in the affidavit and to bring a truthful picture to this court that we should want to portray the correct picture. But what had happened is the engineers of the KMP were to do the integrity test of the piles which we have already done. Unless that integrity test is done, we cannot put the pile cap. So this is where the work was lying stuck at. So unless they do the integrity test, we cannot proceed further. This is why the necessity was there to put in paragraph 4, which possibly felt as a red flag to my learned friend or his client rather. But it is not really a red flag. Unless they do that, I cannot put the pile cap and construct upper structures. So these are the kind of reciprocal cooperations which unless given, we are unable to proceed because we cannot put the pile cap. So these are the things which I had. This is really not a red flag. In a construction contract, these are the practical things which a contractor has to hold for the employer to employ engineers to come and do.
Apart from all this, I am really concerned with regard to the finance of petitioner.
Your lordship,
suppose payment does not come on time, will the work be concluded within the time schedule? Your client will not be able to.
I'll indicate possibly. I should be placing one more clause to your lordship. Kindly take page 51. I shall show the payment. But it cannot be that because they are giving the extensions, they will not make pay. If the contract terms are other, I am not wanting anything extra, barring the contractual payment. Kindly see page 51. I am not on delay. I am on no pay. Kindly see clause 7, 8 and 9. Clause 7 is the payment on intermediate certificate, which necessarily imply that time to time payments would be made on intermediate payment certificates. If my lord kindly turns to page 52, it refers to monthly bills being submitted.
All said and done, suppose the money doesn't trickle in, how will your client complete
your
the
lordship
work?
will kindly not take me amiss. For any construction contract, the monthly payments are provided for that reason. It cannot be that an authority would use their offices to extract a contractual work ends completion
Because
and
the-
not pay, I could have understood the contractual payment terms were otherwise, that after completion I would
No,
pay.
no, I
But I am
follow
not
it.
wanting anything extra.
I follow it, but the payment terms as
But
appearing at
this is
page
one of the reciprocal
33.
obligations that they have to do, but it cannot be a one-way traffic. Well, I am not wanting anything more. Whatever clauses are there, if I am entitled, I will. If I am not, I will not.
According to availability of fund.
I understand. I bow down to that. But the issue is, well, if funds of KMDA is not available, then your lordship is well, wanting a small contractor to.
No, we are
carry
not a
on-
profit earning organization. We are
Funds
completely
lordship
funded
is
by the state
not-
government.
They are not sure of. Then kindly seize the situation. That they are wanting
Yes,
us
that
to
is
do
why
the
we have
entire
put
work
that
without
clause.
taking the pay. But I am not saying that I will stop the work voluntarily. Your lordship will see, Malad, we will not.
Your finances will not permit you to do it.
No, but that is why your lordship has seen that in the contract, the clauses are as such that there will be interim payment certificates and there will be monthly bills. So if that is there in the contract, I'm not wanting your lordship to deviate anything from that. Whatever is there in the contract, it's there. I will not gain anything, your lordship. Taking a fight with KMC will not leave
You
me
may
anywhere.
not gain anything, but the state, the public is going to lose a
It will
lot.
not leave me anywhere, my lord. I will be summoned by them. I will be blacklisted, and I will suffer the consequences. I will not gain anything, my lord. All we require is cooperation from their side as well, and we undertake. My client is there in person in court. I have specifically asked him to come. He says that I want to do the work. That is why I'm there. Otherwise, and
Has he done any such similar works
yes,
before?
with KMD also. With KMD also, he has done 2 previous works. But this is a situation where
And did he receive the payment for the works that he executed?
All the payments in time. And ma'am, it was a bigger capacity overhead reservoir. It was 1250 cubic meter size. These are 640 and 510. Thank you.
And my
Then
lord,
a further affidavit has to come, and clause 6 is there.
yes, my lord, this I shall argue on. On 6, I shall argue that in a construction contract, the law is settled. Time is cannot be of the essence. If it is not so, liquidated damages cannot be invoked. That is one side of the argument. My other side of the argument is that if the work is not delayed due to my fault, and I'm not saying due to respondents' faults or entirely also, the situation was such that things were beyond our control. The lampposts were there on the road, at the middle of the road. The forest was there, and none of us could clear. One had to await the forest permission. The other has to await the WBSED sale permission. So,
please come.
Malad, may I make a one-line rejoinder, Malad? One-line rejoinder, Malad. Though I appreciate, Malad, Mr. Gupta's arguments, Malad, on the liquidated damages part on law. But the problem is that here we are not on the contractual, not really deliberating on the contractual law. We are on the equity aspect. But when he chooses one forum, that is 226, Malad, he has to, Malad, base his case on the equity part. But whether section 74 will be applicable, how much LD is to be imposed, whether Kailashnath will be applicable or not, those are absolutely different questions. We are not arguing on that. But if we are shut out, then we have no way to put the contractor to task.
Acha.
May
An affidavit
before
by
your
the
lordship starts,
petitioner
one more sentence, if your lordship kindly permits.
has filed an affidavit. Stop. Now, affidavit disclosing the time period within which the work will be concluded by him. Stop. Next. The KMDA has sought for a declaration to be submitted by the petitioner declaring that what does this no escalation? Is it the cost?
Malad, it's not, Malad, I would have worded it like that the
Yes.
declaring that the petitioner will not claim any escalation.
Price
Will not
escalation
claim
on
any
total
escalation for
contract.
the extended period.
Is the price
Price escalation, my lord. Price escalation.
declaration for price now declaration that he will not claim any price escalation because of the delay in conclusion of the work, comma, declaration for no claim on the head office overhead. আচ্ছা একটা কাজ করুন কি বললাম the KMDA ওটা কাটুন the KMDA seeks further declaration from the petitioner. Stop. The declaration which the petitioner is required to submit shall be made known to the petitioner by Monday.
Made known to the respondent. my lord.
Achha, by Monday, the petitioner may submit the declaration within 2 days thereafter.
এটা আপনাদেরই দিয়েছেন এই নিন।
Stop. The authority shall thereafter take a call as to whether to permit the petitioner to conclude the work or not. If the authority is of the opinion that the petitioner may be permitted to conclude the work, comma, then such permission shall be intimated to him. Stop. If the authority opines that no permission can be granted to the petitioner, comma, then the same shall also be intimated to the petitioner. Stop. Let the matter be listed on 18th of December 2024.
কবে কবে? 18th. But the interim order be extended.
What is the interim order?
The clause 2, there is an injunction restraining invocation of the clause 2. May it be extended 1 day beyond the next date. Well,
The interim order
what is that?
that is subsisting the be extended till 20th of December 2024 or until further order, whichever is earlier. 20. So, Mr. Bandopadhyay, your client will make known the petitioner what he is, and if he is able to convince your engineer, then it is all right. Otherwise, I don't know what is going on.
So otherwise, we'll have to argue. But I'm really grateful to your lordship going
No,
out of the
I
way in
believe my lord, it will come to
reconciling-
a my lord, positive end.
I'm so
I
glad.
believe this hearing will come to a positive end, my lord.
And since Mr. Bandopadhyay is there, I should also use my good.
And for the course, since both of you all are there.
Grateful, my lord.
Yes. Take care of your health, Mr. Bandopadhyay.
Yes, my lord, grateful, my lord.
Yes.
This
Is your other side there?
For respondent number 7, Bank of India, my lord, I'm being led by Mr. Debashish Saha.
my lord,
He's
I tried
appearing
to
online.
serve the copy, my lord, and I've served the private respondents to their advocates. So, Lordship, the peculiar facts involved in this matter is, Lordship, the petitioner had filed one complaint case before the West Bengal State Consumer Redressal Forum. But directly straight away come to paragraph number.
What is the subject matter of the case before the commission?
This is reflected in paragraph number
Regarding any defect in goods? Defect in goods or services?
services.
Services.
Services, it was a card. Petitioner had advanced made the advance payment for a second-hand car. One first-hand new car
Whatever, for a car.
for a car.
And then what happened?
Car was not given, EMI was constantly being deducted.
All
At that juncture, petitioner moved this application before the Consumer Forum. Well, the annexure P3 will reveal that once this matter was pending, petitioner wanted to obtain the certified copy of the order. And some facts, Lordship, is reflected in the annexure P3. I don't want to read it into open court. This is the fact.
Which page?
Page 35. This is a complaint against such and such, who is the president of the Consumer Forum, District Consumer Forum.
The petitioner is a practicing advocate.
Advocate, my lord.
All right.
My lord, the third paragraph of page 35, I further inform you that the present president has been starting at the bench. The time is given. Next next page, my lord.
Yes. Then what has happened?
So this was Lordship filed. This complaint was filed. And thereafter, Lordship kindly come to the next day. On the basis of this, one application for recusal was made moved before the bench on the ground of personal bias. Now, this was rejected. It was not transferred. So thereafter, the transfer application was moved before the bench. This is before the state forum. Now, the state forum rejected. Thereafter, the petitioner moved before the national forum. And national forum ultimately passed the order, which is in page 30.
Page?
Page 30.
30.
30, P2. And relevant portion is page 32. It says that the Consumer Protection Act 2019 does not have any specific provisions for appeal against the order of the State Commission refusing the application for transfer under section 48 of the Act. Now, this was refused, and ultimately it was stated that the revision can be done. My lord, then this 226 has been invoked because there was the allegation of personal bias, and the learned presiding officer there was an allegation leveled by the petitioner against the presiding officer. A police complaint was also lodged, FIR, which is annexed in page number 43. And in this situation, Lordship, page 43 is the FIR. This was registered. And this was intimated, that this pendency of the writ petition was intimated. Thereafter, also very recently, this order has been passed on 21st November. When this writ petition was pending, it was intimated, but ultimately the date of judgment has been given, fixed by the concerned tribe. So that is the question which has to be decided here.
The question is as to whether an appeal or division of the commission is available.
When complaint was supported by the medical documents, which is also annexed in page 41 onwards. This happened when the matter was pending before the concerned bench. It allegedly happened, my lord.
Is there any provision in the Act For transfer of an application.
Yes, there
That is there. Let me see.
48. This transfer of the cases, it says on the application of the complaint or of its own motion, the State Commission may at any stage of the proceeding transfer any complaint pending before the District Commission to another District Commission within the state if the interest of the justice. Problem cropped up probably because of the word complaint. It is confined to that word. And State Commission rejected my application.
You have not yet got the car. The goods, you didn't get it. And the who is deducting the EMI? The bank. You have taken loan.
My lord, the account has already turned NPA. My lord, am I audible, my lord? My lord, am I
Yes,
audible?
I can hear you.
July.
দেখা যাচ্ছে না ক্যামেরাটা অন করুন স্যার
But my lord, I am unable to open my video. I do not know the reason why, but I am unable to open my video.
Very well.
Is leading.
Yes, yes, I can
Due to
hear
some
you.
technical fault, perhaps.
All right.
The account turned NPA on 4th July 2023, my lord. And till date, the due is more than 3 lakh.
The loan was obtained for purchasing a vehicle. The vehicle has not been delivered to the borrower.
Yes. My lord, what happens, my lord, may I tell, my lord? That we disburse the amount directly in the account of the dealer. The borrower, he approaches us, he makes an application. After the loan is sanctioned, it is directly disbursed to the account of the dealer. After that, if the dealer has not given him the vehicle, my lord, that may not be our subject matter, our lookout. It is a dispute between the dealer and the borrower or the person
I can
concerned.
understand. I can very well understand that. But then I am just trying to find out a solution. Is the dealer here?
Yes, my lord. I am appearing on behalf of the respondent number 3, my lord. My lord, perhaps, my lord, this matter, the issue has been enlarged more than it should have been, my lord. May I submit, my lord?
When will the car be delivered?
Yes, my lord, before the consumer complaint was filed, my lord, the issue before the consumer forum, the complaint which my learned friend has filed before the consumer forum, there is a few days delay in handing over the car. That is what he alleges. Now that is being disputed by us on the ground that the delay was not on the part of the dealer, my lord. Now, prior to the consumer case was filed, my lord, a letter was issued. When the matter came to us, my lord, we advised the client to settle the matter. When the matter came to us, my lord, before filing of the consumer complaint, an email was issued to the complainant, my lord, stating that you can take the car, if you are not satisfied with our services, we can refund the money or we can hand over the car to you, whatever you desire. This I am talking in 2020, my lord, prior to filing of the consumer complaint. Post that, what has happened, my lord? The complainant has filed.
How much money have you received on account of this vehicle?
I have received the entire consideration.
The whole consideration?
I have received the entire consideration. I am ready to give the car, my lord. The issue was, my lord, registration of the car. We had issued a letter to him seeking which RTO would you prefer for registration. There was no response to it. After that, there were various allegations. There was a criminal FIR against our employees, my lord. There has been several revision applications.
What does your client want now? The car, the money, what?
We are ready to give the car.
He has gone all the way to the national forum for this.
He had booked the car in 2020.
So right now he doesn't want the car?
He doesn't want the car. In that case, Lordship, that it has to be decided.
What is to be decided?
That that car was not delivered, Lordship, at the time. So I just took the instruction. He doesn't want the car to be delivered right now.
How much money are you holding?
My lord, I have received 3,83,000 from 83,000 from the complainant and 3 lakhs from the bank, my lord.
Total, how much have you received?
3,83,000, my lord.
Total 383.
383.
Right?
Yes, my
What
lord.
is the due of the bank?
That's more than 3 lakhs as on date.
383 is the figure which the dealer has received from you.
From him, 3, ma'am. From him,
Yes, my
3
lord.
lakhs we have received, my lord, and 83,000 we have received from the complainant.
All right. 3 from the bank and 83 from the complainant.
Yes, ma'am.
What is the due of the bank now? The figure, Mr. Shah.
My lord, 80,000. My lord, 1,80,658 is the principal outstanding due as on 4th July 23. And that part 1,29,00,000 is the uncharged interest. After the account has turned into NPA, the interest is not calculated in the account. My lord knows it very well. The interest is calculated separately. So the uncharged interest is as on date is 1,29,000. So totally
give me
it is
a
coming around 3 lakh,
total
3 lakh or
figure.
some.
Give me a total
My
figure.
lord, 1,80,658
Make the
plus
calculation and let
1,29,000.
me know.
My lord, it is coming around 3,09,658 as on 4th July 2023. Sorry, my lord, sorry, as on 26th November 2023.
Whatever you are
3
holding
lakh.
with the statutory interest, return it to the bank,
My lord,
so that the petitioner's bank account, the NPA will go.
subject to what my lord says, we are not liable to pay back the interest, my lord, because it is our contention that there was no default or deficiency of service on the part of the dealer. This email, my lord, considers it.
1 minute.
My lord.
Maybe there was no deficiency.
My lord.
But in the meantime, the vehicle was not delivered and the money you are holding. And you are enjoying some interest on it?
No, my lord, the money is with respect to a good, the car. It is not that it is lying in my bank account. I am a dealer of Maruti. I have to pay money to Maruti as well for the car. It is not that the money is lying in my bank account and I am enjoying interest on it. That is not the case here.
The vehicle is not there with you. You've sold it off.
The vehicle is with me. I am ready to deliver the vehicle. My lord, just
For the last 4 years, you are holding it. A vehicle. That means it has just got ruined. If the vehicle is there for 4 years without any movement or anything.
There might be a different vehicle, my lord, of the same
Yes.
model and make. There
Right.
might be a
So this
different
is the
vehicle of the
thing,
same.
that there is no vehicle with you. You can always collect a vehicle and deliver it.
The money is not with me, which is bearing interest. I am a dealer of Maruti. I have to pay Maruti the money to get a car. Now I have paid the statutory taxes for registration as well. Around 50,000 odd I have paid for the registration of the car.
The car has not been registered.
That is because of the complainant's delay, my lord.
Whatever.
That is my case.
So how could you pay without the registration being done?
The registration cost has to be paid first. The taxes, etc., which has to be paid, has been
You
paid.
are a dealer and you can always get it adjusted with some other vehicle.
It has been deposited in the particular name, my lord, of the complainant. My lord considers this email. It was written on 17th of November 2020. 17th of November 2020. This was not responded. We have taken a very fair stand with the complainant, my lord. We have at that stage we were even willing to refund the money or the car. We had given a written communication. Despite that being the position, there was a criminal complaint filed by the complainant against my
Yes.
employees. There was
Wait. Bank, Mr. Shah.
Hello.
You please come to a settlement amount so that the thing can be settled and it is not stretched too far. Complaint against the member of the commission and all this thing is going on. It's gone all over to the National Commission.
This, my lord.
No, it is very, seems to be very unhealthy type of things.
Please work out on a figure by which the entire issue can be resolved.
My lord, this complaint also, my lord, perhaps
My lord, may I come back
for not passing interim orders.
Yes, please take instructions and let the petitioner know what are the dues and how much will be the settlement amount and everything, so that the matter is stopped. The court is trying to find out a solution as to how this is the matter of one of your learned brothers.
I understand, my lord.
And it should not be.
That is the reason, my lord. Under my instructions, the client, despite not being at fault, had issued this communication. My lord considers
Very
this.
well.
We have taken a
Keep
very
it with
fair
you.
stand here, my lord.
Please come.
Nichana, my lord.
The petitioner is a practicing advocate. Stop. He, in his personal capacity, filed a complaint before the District Consumer Disputes Redressal Commission at Baripur in the year 2020. On the allegation of bias, the petitioner sought for transfer of the said complaint case. Stop. As the prayer stood refused, the petitioner approached the state forum and thereafter went all the way to the National Consumer Disputes Redressal Commission. Stop. By an order dated 29th of October 2024, the NCDRC opined that the petitioner cannot avail either the remedy of appeal or revision, and the only remedy of the complainant is to approach the Constitutional Court having jurisdiction in the matter to challenge the impugned order. Stop. In view of such direction, the petitioner is here before this court under Article 226 of the Constitution of India. Paragraph. The issue relates to supply of goods within bracket car and deficiency of service on the part of the dealer in delivering the car on time. Stop. The petitioner obtained loan for purchasing the car. Stop. The bank has released the entire payment to the dealer, which the dealer admits to have received. Stop. The car, however, has not been delivered. Stop. The loan account of the petitioner has turned to NPA. Stop. The interest of the account is increasing day by day. The petitioner currently is not inclined to accept the car. Stop. Next. Learned advocate representing the dealer submits that there was hardly any delay on the part of the dealer. Stop. The petitioner deliberately refused to accept the car. Stop. Written communication was made by the dealer, which was not responded to by the petitioner. Stop. The dealer had spent considerable sum for getting the vehicle registered in the name of the petitioner. Stop. Paragraph. Learned advocate for the bank submits that a considerable sum of money is due and pending from the petitioner. Paragraph. Next. Upon hearing the parties and upon perusal of the materials before this court, I am of the opinion that the issue is required to be resolved without any further delay. Stop. The bank is directed to intimate the petitioner the amount that is due and pending so that the same can be paid off to close the loan account. Stop. Next. The calculation shall be forwarded to the petitioner by 4th December. It will be open for the petitioner to enter into talks of settlement with the bank for the purpose of closure of the loan account. The dealer is directed to render all cooperation with the bank and the petitioner. Stop. List on 19th of December 2024.
My lord, just one small indulgence, my lord. There's a criminal case which the complainant has filed against my employees and my managing director, my lord. If that can also be resolved in case there is a resolution, my lord may kindly indicate that, my lord. Because we
You
have
have
been,
mentioned it. I have kept it in mind. Next day, let
my
us
lord,
see
very
how
grateful,
we
my
can
lord.
finish it off.
Very
Please.
grateful, my lord.
This should not be stretched to this
Absolutely.
extent. Very unpalatable.
Grateful.
Sir.
My lord, I am for the writ petitioner. My lord, I'm a union representing the hawkers of Barasat Birati railway station, your lordship.
Is the railway authority here?
My lord, may I indicate?
The petitioners are apprehensive of immediate eviction.
My humble submission as well as this evictions drive, which has been, the notice has been served that proposed to be held on 1st October, in compliance of the directions of this honorable court.
All right.
Already, we had taken eviction drive on 23rd, 23rd September 2024.
And they are occupying the land unauthorizedly, or do they have any license?
They are unauthorized occupants and they are encroaching our railway platforms.
All right.
At Birati railway stations.
All right.
So, one eviction drive was conducted on 23rd September 2024. 70 shops were evicted from the premises, from the railway premises. And rest part, we are going to evict with the help of the police authorities, state police authorities, as per directions of the division from this honorable. Presided over by just our chief justice.
Let me see those orders once. Are you aware of these orders?
My lord, these I have been instructed, my lord. These are the occupants who are occupying the railway side of the railway tracks, not on the railway platform, my lord.
Listen, the platform is also the property of the railway. You just cannot go and block it.
My lord, I'm just want to indicate one thing, your lordship. This I have since the notice was issued since 2023. I have been representing them that give me the opportunity of hearing or something to before eviction drive, my lord. Now, my lord, the point is, your lordship, the similar issue, lordship, was of Chandanagar railway station was before this court was came out. After rejection from this court, your lordship, the hawkers union, your lordship, approached before the honorable Supreme Court, your lordship. Now, on the same issue, my lord, all the same facts, even against the railway authority, Your Lordship, that Honorable Supreme Court admitted the SLP, and after
I can see an order in front of me, which is dated 29th of August 2024, which mentions about eviction.
we are not party of that list.
You
Your
are not
Lordship.
required to be parties. You are not required. If you are aggrieved, approach the court. This court cannot interfere at all.
Your Lordship, Your Lordship, I'm approaching before Your Lordship because of that they are going to evict. They are going to conduct.
Can the single bench sit over the order passed by the division bench?
Well, may I just give me, Lordship, bow down, Your Lordship, bow down. Your Lordship.
Then
What is followed from Your Lordship, I'm bow down before Your Lordship. But one point I have to indicate, Your Lordship, kindly come to page.
tell me what authority you have to occupy the railway property.
My Lord, I am, my Lord, since 40.
You are there since long and you'll stay there for eternity.
My Lord, may I?
What?
The point is, Your Lordship, they have authority under section 147 of the Railways Act to evict. The power is given, my Lord. The difficulties are arising, my Lord, where the power is given, but the process of eviction has not been, procedure has been laid down by the Railways Act. So this dispute.
Now this procedure has been laid down by the division bench in this court's order.
My Lord, may I? My Lord, may I? This similar incident, Your Lordship, where they approach before this Honorable Court, after rejection of this Honorable Court, Your Lordship, they approach the Honorable Supreme Court, Your Lordship. Honorable Supreme Court admitted the SLP, notice or direction was passed for issue was notification to the parties, Your Lordship. And meantime, Honorable Supreme Court is saying about to maintain the status quo, Your Lordship. I'm showing the order, Your Lordship, on a similar issue, Your Lordship, Eastern Railway.
Approach the division bench. I am giving you liberty. You go immediately approach the division bench.
Lordship,
Please come.
Lordship, kindly give me some time to.
Already, we have 2 dates we have failed.
Well, 1st December, Your Lordship, the 1st December. That is also Sunday, Your Lordship.
We couldn't because we have been served our contempt notice.
The petitioners.
Contempt.
The petitioners are and the petitioner is a hawkers union. Stop. The grievance of the petitioner is that the railway authority is taking steps to evict them from the railway platform where they are carrying on business, where its members are carrying on business for a considerable period of time. Stop. The eviction is being done without affording any opportunity of hearing to its members and without serving any notice upon its members. Stop. Prayer has been made to stall the eviction proceeding for the time being. Paragraph. Learned advocate representing the railway authority relies upon an order dated 29th August 2024 passed by the Honorable Pill Bench in WPA within bracket caps P 315 of 2024 within bracket Biplab Kumar Chaudhuri versus Union of India and others. Wherein the court directed the railway administration to commence removal of the encroachment process from 23rd September 2024.
First time we have given, we evicted 70 on 23rd September.
It has been submitted that a few of the occupiers have already been evicted, and the next drive for eviction is on 1st of December 2024. Stop. Paragraph. It has further been submitted that a threat of contempt has been given to the railways for not complying the order passed by the Honorable Division Bench. Paragraph. Prayer has been made to dismiss the writ petition. Paragraph. Upon hearing the parties, and on perusal of the materials on record, it appears that the members of the petitioner do not have any permission from the railway authority for permission/license from the railway authority to raise construction and carry on business on the railway platform. Stop. In a public interest litigation, the Honorable Court directed the railways to evict the unauthorized encroachers. Stop. The railways are acting in compliance of the direction passed by the court. Stop. Next. In view of the above, the action of the railway cannot be faulted. Stop. The relief prayed for by the petitioner cannot be allowed. The writ petition fails and is hereby dismissed.
Your Lordship, give some time, Your Lordship, for that. Lordship, give some Lordship, give some time to approach the division bench, Your Lordship. Give some time to approach the division bench, Your Lordship.
1 week.
And
Lordship,
My lord, 39, my lord, both parties here, my lord, matter of 5 minutes, my lord. 39, both parties are here, my lord. Bank is ready to give me the possession. I am the auction bidder, my lord. I got the property from auction. This is a SURFACE Act was initiated. And my lord, till date, I am not getting possession. This was my defense. It's the bank, my lord. He is ready to.
Property for the United Bank of India. Subsequently, Punjab National Bank have issued the sale certificate. Now, a Section 14 application is pending since a long. Otherwise, there is no impediment to hand over the possession. Lordship, kindly direct will hand over the possession.
Why direction is required? If there is no impediment, you hand over possession. Why do you want to bank upon a
I
court's
don't know
order?
why my learned friend, whether he has added the borrower as party or not, that I don't know,
Then,
my lord.
where is the writ petition?
Yes, ma'am. Item 39, ma'am.
Where is the writ petition? You don't have the copy of the writ
Yes, I
petition?
have the writ petition.
Yes,
Then
I have.
see whether the borrower is a party or not.
Yes. Respond number
Now,
7.
whether the borrower has been served or not, I do not know. Then out of turn, it cannot be taken up. I'm sorry.
Okay.